ठीक है हो गया ऑलरेडी ओके विपिन
one matter, commercial appeal for final hearing. My lord. I have informed the other side. Any date, ma'am.
Lord, serial number 47.
Adjournment. He is seeking for adjournments. For adjournments. Page number 6, 26 to 31.
My lord, serial number 18.
Sir, 18 in order, sir.
Sorry.
Page number 7, 31 to 36.
My lord, I'm for the respondent for 32, my lord. On 7th, the Honorable Supreme Court has passed an order reversing the judgment of Canon India in review petition. So we would like to have 1 week's time to do it, and whether it's the applicability of that.
I appear for the appellant in this matter. The Honorable Single Judge had followed Canon India. Now the Honorable Supreme Court has, in the review petition, has modified the Canon India judgment. My lord, it has been passed. So my learned friend is seeking a week's time so that respondent.
The request of counsel for the respondent to place before the court copy of the judgment passed by the Supreme Court in
Review petition, Canon India.
Just give the details.
Yes.
Re-notify on.
Sir, 212.
Much obliged.
Page number 8.
Just state the details of the
Sir,
case.
I'll give the details.
Page number 8, 37 to 40. Page number 9, 41 to 45.
Your Lordship, serial number 41. I appear for the respondent, Your Lordship. If I may be permitted to request Your Lordship to grant 2 weeks' time in the matter.
Why, man?
Lordship, the arguing counsel's mother is unwell, so he's
Just say that adjournment is sought on behalf of the counsel for the respondent
respondent. Please, my lords.
on the ground of his personal difficulty. Adjourn to.
1612.
Grateful, Your Lordship.
Page number 10, 45 to 50.
Lord, 47. Lord, in 47, I appear for the appellant. Lord, I request for 2 weeks' time. Lord, in this matter, Lord, 3 criminal appeals have been filed by the department against the appellant, which are pending for admission. Lord, the outcome in those appeals may have a bearing on this matter.
Which
Lord,
appeals
that-
have been filed?
Lord,
Lords,
criminal-
those are against prosecution, my lords. That has nothing to do, my lords. It's all independent, my lords. This is against the tribunal.
That have a bearing here.
Lord, Lord, the arguing counsel, Lord, I will.
Say that.
Please, Lord. Lord, I will then make a request, Lord, for Lordship to kindly have.
The
it up.
request, but we want submissions to be filed,
Please, Lord.
both of you.
Please.
Learner though, just say that adjournment is sought by the counsel for the appellant, which is not opposed. The counsel for the parties to file their written submissions along with the judgment they want to rely upon. Within 4 weeks.
1612.
Please, Lord.
My lords, serial number 46, appearing for the petitioner, there's a difficulty with the arguing counsel, my lords. A date will be given. This is for final hearing.
Is this matter not connected to 45?
No, my lords.
No.
No,
46 is not connected.
46 is not connected, my lords.
46 pertains to the state government.
That's right. Yeah. What is your request, ma'am?
My lords, the arguing counsel is not available because of a family.
Adjournment
Occasion.
sought by the counsel for the appellant, which is not opposed, we notify.
1612.
Serial number 52, my lords.
Obliged.
Mr. Sushal Tiwari, my lords, appellant counsel, my lords. Needs a short accommodation, my lords, is not well.
We can hear it.
This was the matter, in fact, Sushal had mentioned last week before your lordship. So lordship.
Okay. Yeah, okay.
My lords,
Just say that re-notify.
212.
public.
Serial number 51, the senior counsel was briefed in this matter, some difficulty today, my lords. Could it be taken up on 9th of December?
Just re-notify it. Just re-notify.
912. Serial number 1. Government advocate, serial number 1.
My lords. Appear for the respondent, maybe it.
This is the case, your lordship.
These are all those matters.
My lords. Your lordships will recall that the order passed in Karthik Agency's case in writ appeal number 1464 of 2024. The impugned order in this case, my lord, at page 60.
Here also it says 25%, no?
My lords. And moreover, the only ground or reason cited by the impugned order is the previous order of the learned single judge, single bench in Karthik Agencies.
But
Which your
tell us
lordship
one thing. See, then it requires some amendment to the provision. No? How would you reconcile? Now let's assume this, we were just thinking on it also. You say 100% penalty. You say what has been said as a pre-deposit is only 25.
Well, no, my lords. This is, my apologies, my lord. The pre-deposit goes to 107. There your lordships are absolutely right. There appears to be some tension, although the revenue stand is clear that it is in addition to, because the pre-deposit for the appeal is only for the right to appeal that does not release, by itself does not release the goods. The release of the goods is independent of the appeal. So that is on a slightly different footing, my lords. But here, my lords, what happens is, once a proceeding under 129 detention takes place, thereafter, in course of that investigation, I find that there is intention to evade. So I start 130 proceedings. 130, once I start, it is liable to be confiscated. It becomes my property and I'm entitled to auction it. Writ petition is filed saying that, look, without completing proceedings under 129, how did you go to 130? My answer is that by amendment, the two provisions have been desegregated, but that's a question of law pending before the single judge. And I'm willing to address your lordships on it. But once 130 is invoked, there is no provision for release at all. It is in fact liable to be confiscated. Relying on the first judgment that your lordship saw and were pleased to modify, these three orders have been passed in serial number 1, 2, and 4, that on 25% deposit, the goods and the conveyance have to be released. So last time, if I may submit, my lords, the protection that your lordships granted me was somewhat of this nature. I'll just keep
No, but tell us one thing.
my lords.
But now you are imposing penalty without deciding the show cause.
Not at all, my lords. He has to participate. Once I'm not imposing anything without hearing him. Show cause notice is issued.
Hearing without passing a final order.
Absolutely, man. Absolutely.
No, in that case, before final order, I think he went to the learned single judge.
Please, the learned single judge says release it, does not stay 130 proceedings. I passed the final order and
Then he went in appeal.
I went in appeal.
You went.
I came before your lordships.
That's right.
There, what happens is he does not participate in the.
But he also went into appellate proceedings against the 130 order.
That he's entitled to do. That goes before another forum, my lord. That doesn't come to the High Court. So precisely, my lords. But what happens is that in the three cases listed today, I'm told that contempts have been filed. There was some urgency because the goods were perishable. Here, my urgency is the order that is relying solely on Karthik Agency's order. I've been asked to release. I will be left recourseless. That judgment has been, order has been modified by your lord.
He has said 25. Now, have you passed final orders under 130?
I have not passed final order.
You have not passed.
I have not passed final.
No.
In one case, I have.
Now, against which order he has gone?
The commencement, the show cause notice, the MOV 10, which is the show cause notice under 130 minutes.
He came to the writ court.
Yes, my lord.
But there is no final order, so he could not have gone to the appellate authority under the act.
No, my lords.
No.
No, my lord.
And at the writ court, it says 25% and release it.
Release. I am unable to release, my lord, because when I pass the final orders, assuming he succeed and he's able to show cause, then the 130 proceedings are dropped. If there is anything under 129, that's a separate issue. But if I release it now, I'm left recourseless without any security. That's my difficulty. And your lordship may kindly see. The calculation is available.
How long does it take to pass a final order? Under 130?
He's not submitted a reply despite 3 summons.
If I may submit, my lord. In fact, my lord, I have submitted an ad interim reply stating that, my lord, I had filed writ petition before this honorable court challenging the correctness of the notice issued. And so therefore, I have made a request asking him to keep in abeyance all further proceedings, my lord. That is the stage.
But tell us one thing, what is the challenge in the before the writ court?
My lord, I have challenged the very jurisdiction of the confiscation proceedings on the ground, my lord, that the entire case what is sought to be made out is that, my lord, the supplier of the goods to me, my lord, is non-existent and that he has
But that's
not
not the merit, no?
Yes.
In fact, my lord, therefore, my submission was, my lord, that there is no jurisdiction so far as I am concerned to
No,
issue,
see-
confiscate my goods.
We are at a show cause. Let's be clear. You will give your stand, possibly they'll agree with you. To challenge a show cause notice, we say nothing, the writ petition is pending there. But
Yes.
what is basically primarily aggrieved is, now what his contention is this. Show cause given, you have to give reply, they will pass an order. If it is against you, she will have a remedy under 130. If they drop the proceeding, that's the end of it.
Please.
No prejudice is going to cause,
Please.
no coercives. But if there is if pending, this process, the release of good by the writ court with the payment of 25% of the total, what is total demand? How much is,
My lord.
tell us one thing, how did you arrive at total demand?
My lord,
Sir, there is a proposal.
your lordships may
But
kindly
without
take-
a final order, can you come to a total demand?
Of course, ma'am. Your lordships may kindly come to page 190 of the writ petition, my lords.
One nine zero.
Yes. Yes.
Yes.
My lord.
My lords, my total demand is 22,16,825, which includes on the goods 18,80,000 and on the conveyance 3,36,000. My lords, now if your lordships take the previous page,
Yes.
there is a how we get to 18,80,000 also derives from the invoice value, my lords. The scrap battery quantity is so much, taxable value is 15,93,000, CGST and SGST amount, and the penalty amounts, my lords, is also shown on page 189, the table under 283. And then again, if I were to make a calculation under 130, the under 283 is the calculation under 122 subclause 3, and under 130 is on page 28, sorry, paragraph 28.4.
Yes.
Well,
No, but how did you arrive at the figure without his show cause?
this is a proposal, man. It's not fine. Based on the investigation I've conducted,
So show cause notice reflect these figures.
it's a proposal.
It's a proposal in the show cause.
Yes.
For
So-
him to reply, for
Yes,
him to.
absolutely. So it's, I would say this, my lord.
So why don't you see it will it not be better for you? You reply and they decide once for all.
Lord, in fact,
And
Lord,
why should be out of pocket that 25% also? Suppose they drop the proceedings. It's end of it for you. There is no claim, no penalty, nothing of that sort. You're getting the point?
I understand.
That's better for you. It's only at a show cause notice. You give a reply and then let them answer it. Now the grievance of the state is that 25%, if at all, if it is finally they decide it is 100% or whatever they have proposed, this,
Yes.
then you have a remedy under 130, you have to pre-deposit 25%. You're getting the point? Then that's the remedy. That's the channel available for you. Even then also it would be 25%.
Not, in fact, not. Here is the case, my lord, where my goods have been detained for more than 2 months, my lord.
You're
And,
right. That's one reason we have asked. You can't keep it. No, 2 months is a long period. See, ultimately, you have to see from his perspective.
If he
also.
participates, it can be closed, my lords.
Lord.
Your lordships are time bounded. Because my investigation is complete. My proposal is in place. He does not participate. Tomorrow he will say the rules of natural justice not followed, then it will get set aside.
My lord, I have filed my reply, my lord. I have
Let him
I have
participate.
informed the
Yes, when will you file it?
appellant. Not,
When will you file your reply, final reply? Is it ready? You will file it to the show cause. You have given an interim reply, it appears.
please.
You give a final reply, let them take a call.
But-
Then what will happen to this interim order?
Your lordships may, my lords, I'm in your lordship's hands. Either this interim order may be set aside, my lord, and he may be relegated to the
Or we can
adjudication
do one
proceedings.
thing.
Or your lordships may take an undertaking from them that they will not precipitate contempt and will participate in the 130 proceedings. I'm in your lordship's hands. It may be
But
subject
if
to the outcome of.
Lord,
both.
if I may submit, Lord, if I may submit. Lord, I've gone through this order, my lord, passed by your lordship. And here, my lord, apart from 25% that has been deposited in view of the learned single judge's order, your lordship is also directed furnishing of a bank guarantee and personal security. Not if I may submit, because of the fact that not a long time has passed, goods have been detained, and not. In fact, I also have to compensate the transporter, not for every day that the goods
Yeah,
are
very
detained.
right, very right.
Not your lordship, I'll furnish a personal bond, my lord, for the balance of the proposed demand. But not then let them release the goods, my lord. So it will
Let him furnish a bank guarantee.
But-
Madam.
How much is the amount? 25% is how much?
Not,
Why don't you give a bank guarantee and we will ask them to decide that 130 proceedings within a time period?
My lords, in this writ petition, my lord, he has furnished a demand draft of 3,98,314.
That's 25%.
Yes, please. My remaining is 18,18,511. Your lordships may direct him to furnish a bank
I'll
guarantee
furnish a
for
bank
18 lakh.
guarantee. I may be permitted to furnish a bank guarantee.
Bank guarantee for the balance amount?
Please.
Then we will say so.
My
Then
lords.
we say nothing
My lord, let
I'm in
them
your
back-
lordships. I'm in your lordships.
and we'll just deal one by one.
Please, my lords.
So this will dispose of the appeal.
This will dispose of the appeal, my lord, and the question of law before the single judge can go on. I'll argue.
That's right. We said the challenge in this appeal is to an order dated what is the order? Single judge order,
Madam.
order dated 4/10/2024, passed by the learned single judge in writ petition number 27141 of 2024, which is a writ petition filed by the respondent herein, whereby the learned single judge, by referring to an order passed by it passed on 9/8/2024 in writ petition number 17265 of 24, has granted an ad interim relief in favor of the respondent, directing the stating, subject to the petitioner depositing 25% of the total demand with the respondent, comma, where does it say the goods shall be released?
My lord, that is as per my prayer, my lord, interim prayer. Lordship may kindly see, Lord.
The goods which have been, the goods and the vehicle also,
With goods and conveyance.
Goods and the
the
vehicle.
goods and the vehicle be released in favor of the respondent herein. Full stop. The submission of learned counsel for the appellant is that it is only the writ petition has been filed at the show cause stage. A final order is yet to be passed. Full stop. Only an interim reply has been received on the show cause notice. Till such time, the respondent furnish a final reply. the proceeding, the order under section 130 of the, which is the
GST Act.
cannot be passed. Full stop. He also submits, the appellant shall be satisfied if the respondent furnish a bank guarantee in favor of who is the officer?
The appellant.
We just want the name of the
Please, my lord. Assistant Commissioner of Commercial Taxes Enforcement.
Assistant Commissioner.
Of Commercial Taxes Enforcement, Ramnagara. The appellant before
You
you.
have to say Ramanagara also?
My lord, Ram.
Ramanagara. The goods as directed, the goods and the vehicle as directed by the learner single judge can be released. The same shall be subject to the, what? Subject to?
The final outcome of the writ petition.
Subject to the final outcome of the writ petition.
My lords, the amount of the bank guarantee your lordships may kindly consider is 18,18,511.
Bank guarantee for an amount of? How much, Mr. Bhatt?
18,18,511.
Just write it down, be clear.
18,18,511.
1818
511.
Full stop. On this next para, on this submission of the learner counsel for the appellant, the learner counsel for the respondent states that as the goods are lying with the appellant for the last 2 months, and there is an urgency, the appellant or the respondent shall furnish a bank guarantee for the said amount within how much time?
Not within a week's time, not.
Within 1 week from today. Full stop. If that be so, learner counsel for the appellant submits that the furnishing the bank guarantee shall be subject to outcome of the writ petition. It is ordered accordingly. In view of the aforesaid order, the learner counsel for the appellant submits the writ petition the appeal be disposed of. It's ordered accordingly.
No. Lordship make observation that upon me furnishing the bank guarantee, the goods will be released.
We have said so.
Please.
We have said,
Very well.
obviously.
Very well.
Furnishing and when will you release the goods on furnishing the bank guarantee?
It will be done forthwithly. If the bank guarantee to my satisfaction is worked.
Okay, let's see the next one.
Serial number 2.
Lord, this is identical to the previous matter. Lord. Only thing the
amount here.
the amount changes, that's all.
Because the remaining amount is 20,15,687.
Just write it down, ma'am. How much is the amount?
20,15,687.
This is the balance 75%.
Yes, my lord. 20,15,687, madam.
And here also, no reply forthcoming,
No, all the same lines.
Same, everything is the same.
except the amount.
Yes, my lord. And the writ petition number, etc.
And just change the writ petition number. Order is the same date,
The order is the same date, my lord.
Same date.
same date, and the amount. These three things are two things. Writ petition number and the amount. Okay, now let's see the fourth one. Rather counsel in the fourth also.
No, madam.
I'm the counsel in the fourth one, your lords.
Then just wait, ma'am. We'll come back. We'll come.
Serial number 3.
Lordship, may allow me to appear. The petition is not served on us. I am for the respondent hearing.
Yes,
And AOR is present there. He would file memo of appearance, my lord.
yes.
Lord, this is a matter where the respondent, Lord, was found involved in using fake invoices to claim input credit. In the sense, there were invoices, but there was no physical movement of goods. So we had evidence of that. We recorded statements. Lord, on 27th of, on 31st of July 2021, the respondent voluntarily made a deposit of 1 crore in terms of section 74(5), where, my lord, if there are any amounts due, along with 15% penalty, the respondent can make the payment. And this is completely controlled by the assessee concerned. The deposit is through online. They generate the DRC-03. So 1 crore was transferred on 31st of July 2021. And about 4 days later, on 3rd of August 2021, by following similar procedure, by generating DRC-03 form, the respondent made another transfer of 1.5 crore. So totally about 2.5 crore was transferred. which we received. Thereafter, my lord, we have initiated the adjudication proceedings. We have issued the show cause notice. The adjudication proceeding is pending. The issue before the learned single judge was, now before that, what happened was, although the voluntary payment was made on 31st July 1st and then on 3rd of August, the writ petition was filed on 16th September. Along with the writ petition, the petitioner files an affidavit, a counsel prepared affidavit, saying that I was coerced, I was brought, there was duress on me to pay. Lord, there is a gap of almost close to 2 months since the first payment. And this, the alleged affidavit.
The affidavit which came for the first time along.
First time, it was not filed before any authority.
In the writ petition, it came.
Writ petition, it came first. So my lord, the fundamental issue that I want to raise before Lordship is, these are all serious disputed questions of fact. But how could the learned single judge decide that there was duress? He accepts the contention that there was duress.
Let's see the finding there.
My lord, the copy is not served on us so far.
Okay.
It's 2 weeks time.
Lord, tell us one thing. Now, what has been said by the learned single judge?
Yes, my lord. The order begins at page 18. Would your lordship have a look at page 36?
It's only the direction is to refund whatever he has deposited.
Yes, on the finding that there was duress.
But that in any case, he has deposited according to you on his own.
Yes. And now, my lord, now what has happened is the adjudication proceedings have started. The total liability is in excess of 5 crore. Lord, and we have already in our show cause notice proposed that we want to appropriate the 2.5 crore towards the liability. So there is additional ground why, my lord, I should not be directed to refund now. Because the adjudication.
That's right, Mr. Kamath. But the only thing is now what the learner single has judged is said he has declared it as illegal.
Yes.
This need to be decided, appeal. Then only the follow-up will have, See, today, what you are saying is insofar as the refund is concerned, surely you will not, we can tell them not to at least precipitate.
Yes.
Fund is concerned.
No, the money is still lying with me.
Yeah, right. You will not refund till such time we hear them also, hear you also.
That is all that. As on today, that is all that.
That's all.
Yes.
But we say nothing also insofar as those, the other proceedings.
No, Lord, the respondent is participating there. That is going on. That's going on in Bombay, not here.
That's going on.
That's going on. He's participating.
No, based on this, he may not seek discharge or he may not seek the dropping of those proceedings. We don't know.
No.
My lord.
My instructions are that the respondent is participating in those proceedings.
Okay, very well. We say nothing. In fact, we say nothing. We are not concerned with all.
Very short point, lordship may fix a date.
My lords, may I?
Yes, ma'am. Yes.
My lords, the statement by my learned friend about the show cause notice is wrong because if my lords, I do not know whether they have attached or not. Show cause notice on page 24 did not include the amount of 2.5 crore as a self-ascertainment tax at all. And if my lords would allow me to go.
No, we'll serve a copy. Learned friend can argue. We'll serve a copy. She can argue.
1 minute.
Yes.
Whatever you have shown, I am showing, please. Lordship may go to para 24 onwards, 25 onwards of this petition order by the single bench. Lordship may see.
Of what paragraph of what?
Of the order in appeal.
In the impugned order.
My lords, yes.
Yes.
Impugned order. Lordship may see there the honorable judge has given a finding that these authorities have not even considered this as a self-ascertainment in show cause notice. May I be permitted to read that, my lords?
Which para you are saying, ma'am?
25, 26, and 28. 3 paragraphs. My lords. My
But
lords.
if it is on merits, if my learned friend is
No.
ready,
I am only on refund of self-ascertainment.
Submission is based on only on the impugned order. Not the
Precisely.
No, if my learned friend is arguing by
we
reference
don't
to
think,
impugned
ma'am.
order.
My
Yes,
lords,
ma'am.
I am opposing because let me point out, my lord, in addition to these 3 paragraphs I'll read, the show cause notice was issued in 2022, November 22. I have fully complied with everything. All the details are already submitted by me. Everything, my lord.
No, we will look into it. Would you like to look into the appeal or not?
My lord, I would like to. I need a copy
So that's
before
what
my
better
lords.
would be. We'll ask them to supply a copy to the council.
My lord, I'm only worried about my lord's stay against the refund. So the matter may be kept within a week's time. I will argue before my lord and then
No,
my
that
lord.
surely, but we have to balance the equities, na?
My lord, I am fully with my lords for that. But
But
I would be,
then surely you would not seek the compliance of this impugned order till the next day.
my lord, yes, but next date should be as soon as possible. The minute they serve me
That
copy.
we will see,
I'll do
ma'am.
it.
We have to see. There are others also. Yes, just say this issue notice. So insert sub notice for the respondent. Let a copy of the appeal be given to the counsel appearing for the respondent. The complete record is here, whatever there was before the learner single judge.
Yes.
Appropriate shall be the counsel for the parties shall file their written submissions along with the judgment they want to rely upon within 2 weeks.
My lords.
Okay.
Oblige.
Now, can we take your submission on record that you will not seek compliance of the impugned order till the next
My
day?
lords, of course, my lords.
The learner counsel for the respondent on instruction states that she shall not press the compliance of the impugned order dated 26 September 2024 passed by the learner single judge in writ petition number 17853 of 2021 till the next date of it. The submission is taken on record. Just give a date after 2 weeks, December 1st week, just give.
Oblige, my lords. I will file my submission much before
Yes,
that.
only file your submissions.
My lords, please, obliged.
212.
212.
212.
Obliged, yes.
No, can it be 912?
Just tell them, just
912. 912.
9th of December, ma'am.
Okay with me, my lords.
I'm grateful.
Thank you.
Grateful, my lords.
Serial number 4, government advocate.
Yes. Now, what is this?
But here, what has happened is that the final order under 130 has been passed. And a demand
Has been passed?
has been
Yes,
passed.
yes, your lords.
Oh, and what is the interim here?
Your lords, the same interim order as serial number
Same
1
order
and
on the
2.
Same day.
Ma'am, tell us one thing.
Yes, your lords.
If you have an interim, if there is a final order passed, is it against you, the final order?
Yes, your lords, I am the bona fide purchaser of the
One
goods.
minute,
Your
just-
lords. Yes, your lords.
All these pleas would be available before the appellate authority. Are we right?
Yes, yes, your lords.
So, and there is a provision for pre-deposit also.
You know, the provision for pre-deposit applies only to 129
Okay,
and not to 130 minutes.
very well.
Lords, the
The
proceeding.
question is, they may appeal. The question is whether they can, once a final 130 has been passed, whether they can,
See, we don't want to make their writ petition infructuous. Let's be very clear.
Very
They are before the single judge on certain grounds.
if they,
Should not make the writ petition infructuous.
Very
Now,
well.
what is your grievance? Tell us now.
my grievance only is this, that if pending their appeal, they wish to take the goods back, they may make a deposit similar to what your lordships have directed, 25% in bank and the remaining by way of a bank guarantee. That's my only submission, limited submission.
What do you say, ma'am, on that?
Yes, your lords, the similar order can be passed, your lords.
You can do that?
Yes, yes, your lords. Keep the writ petition. We'll argue before the writ bench, your lord.
Okay.
My lords, what has happened is the owner of the conveyance has paid an amount of 3,78,000 and taken his conveyance back. So the remainder over here, they will have to provide a cash deposit or a bank deposit of 5,37,689 and a bank guarantee for 16,13,061
For what?
for release of goods, for the release of the goods.
So you are giving, now this is, we are not including the conveyance. or
Yes,
the-
I've subtracted
Take it.
3,78,000 for the conveyance from the total.
How much is the amount?
My lords, the bank deposit is 5,37,689.
You are not concerned. What is the balance they have to give the bank
They
guarantee?
have, no, that's my submission, no? They have not deposited it in the bank.
So they have not.
They have not.
Your lords, we have we have produced the DD, we have given a representation. They have not taken our DD and record, your lords. We have given several representations regarding that.
Then
I've
why
also
the
filed a-
Officer is here, why don't you take the DD?
We have emailed the DD as well, your
No, no,
lords.
DD doesn't work on email.
We have shown them, we have gone to the, physically we've gone, they've not taken it, your lords. We have filed a contempt with regarding to that.
They've apparently sent the DD by WhatsApp.
No, your lords, we have gone physically there to give the
take it now,
DD.
madam.
He's not taken it, your
The
lords.
most high tech, huh?
Your lords, we will produce the DD, your
Have
lords.
the DD?
We don't have it right now.
Don't
We'll
have-
produce it before the
In
day.
course of the day.
No. You be satisfied if the complete amount is given by way of bank guarantee?
No, my lords.
You would not be. Now, what is how much is DD for, ma'am?
5 lakhs.
5,37,689.
And what would be the balance? 75?
16 lakhs, 13,061. 1613,061. And the DD is 537,689.
Now, when are you giving the DD to them?
Today, Your Lords, by the end of the
You will
day.
give it?
Yes, Your Lords.
Okay. The challenge in this appeal is to an order dated to an order dated 4/10/2024 passed by the learned single judge in writ petition number. What is the writ petition number, Mr. Burke?
27303, Your Lords.
27
303.
305
303.
303 of 2024,
Yes, Your Lords.
whereby the learned single judge has granted an ad interim relief in favor of the respondent by directing the appellant herein to release the goods and the vehicle.
Only goods, Your Lords.
Goods and the vehicle, they are not concerned with the vehicle.
To release the goods in favor of the respondent herein on their deposit, on the respondent depositing an amount of 25% of the total demand made by the appellant herein. The only submission of the learner counsel for the appellant is that the final order under section 130 of the so-and-so act has been passed, and the remedy for the respondent is to seek to file an appeal against the said order. In any case, it is a submission that 25% would not suffice the requirement of the demand, and as such, the respondent be directed to deposit, to furnish a bank guarantee in favor of the officer's designation.
Commercial tax officer, enforcement 34, Bengaluru.
34, Bengaluru. So that the appellant herein can release the goods in terms of the direction given by the learned single judge in the impugned order. The learned counsel appearing for the respondent is agreeable to the said submission made by the learned counsel for the appellant. If that be so, the full stop. Just say that the learned counsel for the appellant also states, this is before, also states that despite the direction of the learned single judge, the respondent has not even deposited an amount of the 25% of the amount as directed, which shall be 537,689. 537,689. Full stop. Then he will say full stop. They are noting the aforesaid submission, comma, and also the submission made by the learned counsel for the respondent. Though attempts were made earlier by the respondent to give the DD.
And contempt petition has been filed, Your Lords.
To give the demand draft to the officer of the appellant, comma, without going into the said issues, the respondent shall deposit the demand draft with the officer of the appellant for an amount of 537,689 during the course of the day. Don't wait for the order, you just deposit it.
Yes, Your Lords.
Full stop. She also submits that the bank guarantee for an amount of 1613,061 shall be furnished to the furnished in the name of the aforesaid officer within
Commercial tax officer.
within
enforcement
1 week from today. Full stop. Noting the said they are taking the submission made by the learned counsel for the respondent on record, comma, the appeal is disposed of. The deposit shall be subject to the deposit shall be subject to the final outcome of the writ petition.
My lords.
Yes.
Keep it.
Serial number 5.
Please, my lords. My lords, I appear for the appellant in this case. My lords,
Yes.
post the filing of this appeal, the tribunal has corrected its order in miscellaneous application filed by us, and that order is in my favor now. So we'd like to withdraw this appeal, if my lords may kindly allow that, with the liberty to revive.
No one for this revenue.
Serial number
For the
5.
notice for the respondents.
He wants to withdraw it. Just say, we'll mark your presence.
Please, Lord. Much
Okay.
obliged, Lord.
The learned counsel for the appellant submits that he has instructions to withdraw the appeal. Okay.
Withdraw the appeal. And my lords, if it can be observed in this order that The liberty is granted to the appellant to revive the appeal in case department agitates the MA order.
We say nothing. See, that's in your favor, na?
Right, right.
You have instruction to withdraw. Let's dismiss as withdrawn.
Yes, sir.
Just note Mr. Sanmati's appearance.
My lords, can the
Next.
objections also, office objections can also be
Now that everything goes now, once
Much
appeal
obliged.
withdrawn.
much obliged.
Yes.
Next.
No, Anand. Serial number 6.
My lord, the issue pertains to, my lords, the grant of interest on refund of
You're
bank
ready?
guarantee, my lords.
You're ready?
My lord, the thing is, my lords, I am supposed to file a
Only
IA,
till
my
here-
lords.
Till here you pass over.
One submission, my lords.
Yes.
My lord, there is some error in the online filing, my lords. The registry may be directed to receive the physical copies of the IA, my lords. IA for
Which IA?
dispensation, IA for dispensation, my lord. There are certain office objections, my lord.
Dispensation, we'll just come back,
Please.
pass over.
Please.
7. Serial number 7.
My lords, I'm appearing for the appellant in serial number 7.1, my lords. Pray for 2 weeks' time to file submissions, my lords. Synopsis.
You appear for the respondents?
Please.
Just say that the submissions be filed within 4 weeks. List on.
Grateful.
125. Serial number 8, Shivani Krishnan.
Respond number 1.
Here for the appellant, my lord. My lord, the second and third respondents are in Korea. My lord, I could not effect summons upon them, so I'll be filing an application to serve upon them through the Indian embassy. But my lord, the first respondent is a partnership firm. The second and third respondent are the partners. My learned friend is willing to take notice on their behalf. In fact, last time it was submitted that he would seek instructions on that. Then, my lord, it could be saved, and I'm ready even today, this matter.
My lords, we'll make we'll file application, wakalats on behalf of 2 and 3, 4 weeks' time every time.
No, would you be appearing for 2 and 3?
2 and 3, because we are not yet received any, so we sent a mail, my lords, we have not got any reply. We'll again remind them. If
But
they,
in fact,
Just say that respondent 2 and 3 are still unserved. Then a counsel for the respondent seeks time to take instructions. Whether to appear for the said respondents. Okay?
because they are the partners of the firm. First respondent is a partnership firm. The
Huh.
second and third respondent are the partners.
That's right. But let him take instructions.
Yes, my
no?
lord.
Where are they based in the country only?
No,
here?
no, they are in Korea,
Yes.
South
They
Korea.
have gone back.
Yes, they have gone back.
they are not, they have been banned from entering the,
No, that is because of the
because of the
violations
proceedings.
under the Foreign Exchange Management Act. That's nothing to do with us. They're not able to come.
Would you like to take instructions?
We'll take instructions. And in the meanwhile, the property may be secured by deploying any security measures by the appellants, because from the past 5 years, nothing is, they have removed almost all the iron fixtures.
But I'm ready even today in this matter. Well, if it takes.
No, we don't mind. We want
fact-
them to be served or not.
Yes, my lord, but in the last occasion, my lord.
Last order, at least what I have before us
Yes,
is,
my lord, we had to serve through the Indian embassy. Yes, I understand.
no,
my lord.
just show us the last order. Returnable on, we only pass this.
Then I had prepared an application to have it served through the Indian embassy. My lord, I didn't get the application in
You don't
time.
mind, then, no, then we will not allow. You tell Mr. Unnikrishnan, what do you want?
My lord, if my learned friend is willing to take notice, I'm ready. Otherwise, my lord, I will take steps. I need only a week's time.
Suppose this is the same, this would be the position
Then,
next
my
week.
lord, I'll file an application tomorrow before this honorable
That-
court.
that-
I'll do that. Tomorrow itself, I'll file it. And
So
my
we
lord,
take your submission that you did not get any response.
We are not got any response.
That's right. Who is now briefing, who is now giving instruction for the firm?
The authorized person, the firm. Mr.
They must be the partners only.
No, is the authorized person is now 1 minute. Secret. One Muthu Kumar is giving. Is authorized representative of the.
So then you say this. Just say this, the learner counsel for the respondent number 1 states, despite his efforts, he could not get any instruction from respondent number 2 and 3. That's right?
Yes, ma'am.
Mr. Unikrishnan states that he shall file an appropriate application for service on respondent number 2 and 3 through the Indian Embassy in Seoul.
Yes, yes.
That his request re-notified.
9th of January.
Lord, serial number 9. In this matter, my lord, on the last occasion, it was pointed out that the export bills were amended to the effect that they can be given the benefit. My lord, in view of this, I have placed before the commissioner and they have put up the file for acceptance of those amended bills, my lord. So, and there is one more judgment, similar judgment, where the writ appeal of this honorable court has been put up for acceptance. Maybe a week's time, I may file suitable memo in regarding that after taking instructions, my lord.
Yes,
My lords, there is a decision in this regard, similar issue by the very same court.
Even in view of that also, they have been put up the file, my lord. So,
in the request of counsel for the petitioner, appellant,
in writ appeal, my lord.
in writ appeal number, this 6.1, no, 9.1.
9.1, my lords.
9.1.
I represent the.
You are in the contempt.
I'm in contempt, my lords. Now, since they have decided to, my lords, consider the case of the petitioner before the.
You are for the foreign trade.
Customs, my lord.
Customs.
Customs.
In WA 525/2022,
In contempt 2 and 4, I will take notice, my lord. They are customs. In contempt matter 2 and 4, that is principal and deputy commissioner customs.
2 and 4. Respondents 2 and 4.
Respondent.
2 and 4, just mark his attendance and rest you will mark
Madam.
Mr. Rajshekhar's appearance. The others you will be appearing.
Madam.
Okay, re-notify. When do you want?
25th, my lord.
25th.
Obliged, my lords.
Last date appearing, my lords, the state has to, my lords, consider.
I know.
Serial number 10.
2 weeks time, my lords, file better affidavit. Shall is not, there's some difficulty today, my lord.
What do you want? You just show the last file.
Lords, it's for filing better affidavit, ma'am.
10.
What do you want?
Lords, 2 weeks time, my lords, for filing better affidavit, ma'am.
Just say this, counsel for the appellant seeks and is allowed 4 weeks to file the additional affidavit.
Six 125. 6 125, sir. Serial number 11, Shriddhi. 11.
Lord, this is the issue where the quoting of the DIN number, allocation of the DIN number and inscription of that on the order is the issue. My lord, in order to ensure that there is a proper audit trail of all the communications sent by the Income Tax Department, the Central Board of Direct Taxes had issued a circular on 14th of August 2019, by which, my lord, the CBDT held that any correspondence that we send, whether it is notice, order, any communication, it should be allocated a DIN number and it should be quoted on the body. Now, my lord, the Income Tax Department uses a software called as the ITBA, Income Tax Business Application. Generally, everything is fed into it. For example, if I have to create a notice, I feed the notice into the ITBA. And then when I say click, everything is done, it generates a DIN number, inscribes the DIN number on the notice, and it is dispatched along with the intimation letter through email. That intimation letter will have its own DIN number. Now, in the present case, what has happened is, one of the other methods is, I can still prepare on a Word document, I can prepare an order and I can scan it. I can load it into the ITBA. It will still generate a DIN number. When I do that, I will have to either handwrite it or type out the letter. Which there is an audit trail. I have generated a DIN number and I have inscribed the DIN number. It is not a manual. Manual is where someone is completely outside the office. or there is a serious error in the system, you cannot do. Then there is manual. So what circumstances manual orders can be passed is stipulated. In this case, the order was passed, the revisional order under section 263 was passed separately, and in a PDF document was made, and then it was fed into the system. It generated a DIN number. The officer hand wrote the DIN number, and then along with an intimation, it was sent. The intimation quoted the DIN number of the order. So therefore, my respectful submission is there is complete compliance with the circular.
But why there are two DIN numbers in this? There were.
No, one is for the order, the other is for the intimation letter.
Oh.
The intimation letter should have its own DIN number. That is the requirement.
And that's the reason why the ITAT has.
Yes, my lord. I mean, my lord, there are several orders in this. I mean, similar matters pending before the ITAT. All our orders are nullified on the sole ground that the DIN number has not been quoted or it is handwritten. In all those cases, my lord, there is allocation of DIN number. There was one case before the Honorable Delhi High Court where there was no, in a case called Brandix, there the DIN number was not generated at all. So factually, it's a different case. Now that is pending before the Honorable Supreme Court.
Tell us one thing, will DIN number make such a difference?
No, my lord, only to ensure that there is an audit trail. Not here, my lord, I'm able to demonstrate there is an audit trail. Not the procedure is only a handmaid of the justice. No, it cannot nullify the order passed. Otherwise, my lord, there is absolutely no issues. My lord, on the previous occasions, my lord, on behalf of the other side, a submission was made that in the case of Brandix, where there was no allocation or generation of DIN number, the Honorable Delhi High Court had upheld the ITAT order that is now pending before the Honorable Supreme Court. There, my lord, we do not know when it will be listed and when it will be taken up. My lord, substantial revenue is held up.
So what the ultimately ITAT says is that without a DIN number is violation of your own instruction.
Yes.
That's right.
Yes.
That's the reason it invalidated the everything.
Yes. But in this case, my lord, I have filed a memo on 4th of September 2024. I'm not sure if that is scanned.
Admit it, I think that issue is pending. What do you say?
My lord, my submission is twofold, my lord. Point number one, the issue whether DIN is valid or not arises out of not only the circular, and apart from that, the various press notes and conferences given by the finance minister, where she has clearly told the industry that if the DIN number is not there, that document pone me feco. This is precisely the words that I'm leaving aside the system outside the circular is also there. My case before your lordship today is that, my lord, the issue of Brandix, the Delhi High Court is pending in the Supreme Court, and there are more than 30-40 matters pending in the tribunal. This got disposed of earlier than that, and the revenue is taking a contention in the tribunal that till the Brandix is decided, they should not dispose of any other matter.
But at least that is not my submission.
Let me think.
No, these things I would like to correct immediately. I have appeared before the ITAT and that was not my submission.
That is very much the submission. Otherwise, the point, my lord, they are saying the Brandix has been stayed with the Supreme Court, and consequently, the request to not hear the matter of DIN are available in the tribunal, and six matters are pending.
You are saying wherever this kind of a matter comes before ITAT, that should not be heard.
That is precisely their car. We want it to be heard.
That's what the submission you are making.
That is the submission made by the revenue, according to me. We want to hear the matter and follow, because not.
Maybe possibly to await the Supreme Court.
Yes, madam.
That can be the
No,
reason.
that's in fact, my lord, I have moved this matter before the earlier bench also had moved. My lord, our substantial revenue is held up. My lord, we do not know when the Honorable Supreme Court will take up the matter for hearing. We cannot wait till then. My lord, there is nothing that bars this Honorable Court from proceeding to hear this matter. There is no stay of proceedings, nothing. So therefore, in the normal course, it must be heard. And considering that, my lord, large public interest is involved.
So Delhi High Court has been stayed?
Stayed, my lord. Stayed, my lord.
Yes.
Delhi High Court has been stayed. The Calcutta High Court has also.
So then what is the effect, Mr. Shankar, of the stay granted by the Supreme Court?
That is the decision of the Supreme Court in Chamberlain Mopeds, is that stay granted by Supreme Court will not obviate the judgment. Ratio is there. There is no quarrel in the proposition.
You can argue that surely, but to say that.
No, I'm only saying that the Delhi High Court has only persuasive value over your lordship. There is no quarrel about the proposition. Same thing, the Calcutta High Court has also taken a similar view. And one more court has also, there are three high courts have taken a similar view that DIN is absolutely mandatory. And in this case, there are some facts also that have to be brought to your lordship notice in terms of whether they really put the manual one in the Their submission is that the manual one has been handwritten and uploaded. I can demonstrate your lordship right away. Even today, the manual one is not there in the ITB
But
portal.
tell us one thing, what we were thinking. Now, once it has been held to be invalid, will not be the process which is contemplated under this instructions issued by the CBDT circular of 19 or 2019 would again be followed and ensure that the proper order is passed with a proper DIN number?
That would be one way of looking at it, my lord. The other way of looking at it, my lord, is that a lot of these orders have time limits. As by that, let us assume a DIN has not been put on an assessment order. I'm just putting a question to myself for elucidating the point. The DIN number not put on the assessment order before the 31st March, the time barring date, will make the order barred by limitation. That will not again revive. A law of limitation, your lordship are fully aware of. There's no setting aside back to give a revival issue. And that is one of the reasons the department has taken up the Brandix matter, taken up to Supreme Court. There are two other matters also. Matter is pending in the Supreme Court.
We'll admit it. Let's see.
Well, it is already admitted.
It's admitted.
This
Today it has come for order.
This appeal is admitted.
Petitions. Counsel for the.
Lord, would your lordship have it in December or something?
No, we are only thinking, Mr. Khan, we will have it. We have no issue on this.
Yes.
No, whether appropriate will be to await the Supreme Court or not.
So that, my lord, there is a lot of uncertainty about when the matter would be heard. My lord, I heard my learned
You
friend
can
say,
still mention a matter there.
my lord, I heard my learned friend say that DIN is very important, and I fully concur with him. DIN is important. Without DIN, of course, it has to be konime fegna. But in this case, my contention is that in all the cases that I'm fighting, DIN is generated. Mere non-inscription by a digital system will not invalidate my order. I'm able to furnish the DIN number.
How did you prove that DIN was generated?
I've handwritten on the order.
That order is, I will.
The intimation letter, which is issued on this very same moment, quotes the DIN number of the order.
But tell us one thing, you must also ponder, think over it. Suppose for a moment, in any case where possibly you would be saying that in the facts of this case, it could not have been invalidated, the order by the ITAT.
Yes.
It can so happen in a case where the DIN has not been generated.
No, if DIN is not generated, I have no case.
There you have no.
I concede. If DIN is not generated, I have no case. I straight away concede that point.
Let's see,
My case is DIN is generated and it may not be quoted on the body of the order in a digital format. Either it would be handwritten or it would be mentioned in the intimation letter, which accompanies the order.
File your submissions, file that High Court
Lord,
also. We'll have
in
it.
fact, my lord, I have filed an affidavit of the officer describing the entire process,
You
how
have
the
done
DIN is generated. Along with
that, Mr. Shankar, the affidavit which they have filed.
what procedure is followed, under what circumstances.
Served on it 2 days back.
Is the High Court judgment here?
No, we have served it in September.
No, is the Delhi High Court here?
Not
Delhi
sure.
High Court judgment.
No, you are ready to argue, both of you, then possibly, but you have to only assist us on this.
My submission, my lord, my first submission is like, my lord, in view of the fact that on this DIN matter, several aspects have been contended by different assessees, and all of them are pending in the tribunal, several of them, only one has reached your lordship. My respectful submission to lordship is that if the department want to proceed with DIN, let them proceed with all the orders, let all of them come so that the entire gambit, I may argue only one aspect.
No,
of the
why?
matter.
We are on a principle.
But we have asked him. The specific query, and that's what he's trying to urge also. He's saying it is a case where DIN was generated. It was not inscribed, not depicted on the order.
All of them, the tribal, half of them are in the same lines.
Yes.
Right. So very well. See, it's like this. Any view taken by us
Is bound by them.
it will be bound. That's right. So we can consider rather than waiting for all of them to come over here.
Yes.
We
Your
can do
lordship
that.
Yes,
will have
lordship may lay down the
lordship will
principles.
have lordship will have the benefit of seven. Each one will have a different point.
Right, then Mr. Shankar, every issue
Sure.
will be. and we have
In
to-
that case, my lord, your lordship
No,
may
that-
stay
that-
the assessment
that
order,
is
let
the-
them deposit the amount in dispute.
I should
If
have.
they want me to wait until the Supreme Court decides,
Need to decide the issue first.
yes,
My lord,
that is all that I am
our
urging.
Submission is point number one. Point number two, then the matter is seized by the Supreme Court. In fact, there are authorities to say that it is better that we await the decision of the Supreme Court. I can place.
That's what we are telling him.
Yes, madam.
That's
That is
what
how,
we are
that
putting it to him.
No, my lord, for me,
I
my
submit
lord,
that view, my lord.
it's not in public
Wants
interest.
to see the Supreme Court orders also.
Yes, madam.
The one which, Mr. Kamath, the one which has been passed, staying
Yes.
there. Let's see that order
Sure,
also.
my lord,
Let's
I'll
see.
furnish it before lordship.
Yeah, show us.
My lord, para 9 of this order,
This is Delhi High Court.
Delhi High Court. This was the matter which went to Supreme Court.
Here also didn't generated.
No, para 9 of this order. In the instant case, there is nothing on record to show that according to the appellant stroke revenue, failure to allocate DIN arose out of exceptional circumstances which are set forth. So there was a complete failure for allocation of. In my case, there is no failure. There is DIN generated and allocated.
Where is the Supreme Court order staying?
Yeah.
You have?
Currently, my lord, I don't have.
We'll have it. I think. If you are ready, we can hear it. We'll set out for hearing.
Fix a date, my lord, kindly fix a date.
What do you say?
I'm just thinking, my lord, what?
Processing.
Because it's too much. Major, the other two issues in this case, my lord, is I also request your lordship to post it after the Supreme Court order is my first contention.
See,
And
that,
if you're-
we say nothing.
Seriously opposed.
You file your brief note of submission and you must file the order of the Supreme Court.
Yes, please.
We will see what was the intent of the Honorable Supreme Court, whether that need to be decided first or we can go ahead. We'll
Deeply
see
obliged.
it, everything. And we will hear you on that aspect also.
Yes, my lord.
Otherwise, it's a short issue.
Yes, my
Well,
lord.
it is not only short. In this case, little more complicated because the original records are required. Basically, because my lord, my friend says it is handwritten in the DIN order. It is factually not correct. So I would like to produce those records.
No, are you contesting the facts also, the factual aspect of the
The
case?
factual aspect of my submission of my friend that the DIN has been handwritten and uploaded in the portal is factually not correct. Even this morning, I've been checking it. The
Okay,
portal
let's
does not contain handwritten. It was only an intimation letter is there.
Let's come to the stage one. He said DIN has been generated.
The DIN has not been generated as per the board circular is my first contention. Second contention is it has been generated by an intimation. There is no quarrel that intimation letter also I have a copy with me. 3, that intimation letter DIN, what is written in the intimation letter DIN is not handwritten in the purportedly in the subsequent.
Get the
hand-
records also, Mr. Kamath. Counsel for the parties to file the brief written note of, just say written submissions. Along with the judgment they want to rely upon. Okay, list on, when do you want both of you?
My lordship
When do
may,
The
lordship
Supreme
may
Court
direct
is
the
hearing the
tribunal to
matter.
send the records.
Which records?
Tribunal records.
No, we are concerned with the official records, not the tribunal record.
I mean, the tribunal record, my lord.
The tribunal has requisitioned the official records there.
The tribunal
There is no-
record, which we have filed,
That is what
the
the.
original order which I have with me, copy, does not have manual handwritten DIN.
So that will be in their position also in their official records.
Yes, we'll furnish it.
Official record, what actually happened in this case, my lord, is they made a submission before the tribunal saying that it is handwritten. And they produced one copy. We produced the original which did not have it. Then the two members found that in one member's it is handwritten, in one member's it is blank. Because I filed the appeal, it is not their appeal. So they were very perturbed by saying, how can it be there in one number and not number? And anyhow, we are not going into it at this point of time. And they passed the order based on DIN. That is the actual facts of it, which I will also place on record. So that is why my request to your lordship, I have also taken by a certified copy of both the orders. The two orders of DIN purported to be handwritten by the revenue is there in one file and not in another file in this case.
So we hope that we will get all the record from the tribunals.
Your lordship may direct them.
We will call for it. We hope, we don't want anything further to become. Just say that the record from the ITAT in respect of appeal number.
Appeal number ready?
Appeal number
625 stroke BANG.
ITA
stroke-
number 625/bang BANG/2021. Assessment year 2011-12.
Pronounced on 6/12/22, my lord.
Will be requisitioned before the next date of hearing.
Would your lordship call it on 9th of?
January, my lord.
No.
Let the
Before
Supreme Court order
vacation.
come, my lord. I
No, let it be before.
We'll
9th.
see that. We'll keep that. You are open. Your submission would be still open, Mr. Shankar.
There is a month's time for him to file his returns. I'm grateful.
Your lordship may considering 9th, my lord. 9th.
9. You have any difficulty? Tell us.
Following week, my lord. 9th is one of my very close friends' wedding is there. Children.
Whichever date.
The following week,
Pardon?
16th.
16th.
But it may be too close to the
It's
vacation.
all right, Mr. Kaman. This issue, if both are ready, will not take much of a time.
Can it be on 10th, my lord, if there is some?
Purely factual, we will see it.
can it be on 10th?
I will also like to submit, just for my friends' notice also, the Calcutta High Court has taken a view that, I will also place that, just for your lordship.
That's right. We are saying so. You file all your submissions in
yes.
your favor.
Yes, ma'am.
We are saying submissions and all the
Sending
judgments.
intimation letter is not sufficient, and that matter also has been taken to Supreme Court, and that matter also been tagged with grantings and stayed.
So you can still argue even where the DIN has been generated, the ITAT which has invalidated the order has been upheld till Supreme Court. You can still argue that. File your submissions, file all your orders. Now he wants 10th. You have any issue on that?
Lordship may keep it to 13th, my lord, if it's.
Oh, we should have Monday, Mr. Kamath.
Monday,
That's Monday. We generally have.
If your lordships can make an exception for
No,
this.
we can definitely.
No, but
Why not?
16th, my lord, generally, my lord, the council will say after call after vacation, my lord.
When is the vacation?
The very next week is the.
5 days thereafter, huge time.
Yes, my lord. We'll assist the court.
No, please have it any day during that week, not the week of 9th. I mean, if your lordships can kindly.
You want weeks commencing 9th?
Yes, my lord, sir.
Okay. 10th, 11th, 12th, whichever date you want, Mr. Shankar.
13th, my lord.
Huh?
Well, 13th is Friday, better. I mean, Friday is.
Okay, forget, we will give you date. Come on 11th.
Yes.
11th.
I'm grateful.
What is difficulty? If we have any difficulty, we will ready to accommodate. Except that, tell us.
My lord, difficulties are there between 9th to 12th.
Okay, very well. Then Mr. Kamath, he has your counsel, we will have it on 16th. Let it be.
Right.
Keep your blame.
Counsel has a difficulty. Next.
Seal number 12, government advocate. 12.
This matter is one in a series of matters. And in
What
all.
is the objection?
Well,
There is some objection, does not tally with the description in the repetition.
I'll have that, my lords, what has happened is, I'll have that corrected. What has happened is that in a series of connected matters, my condonation application has been allowed, and in all the connected matters, my stay application has been dismissed, and matters are pending for final hearing. So, your lordship may record my undertaking that the objections will be complied with within the week. And if your lordships are pleased to treat it on.
What is the issue?
My lords, the issue is when a business entity has more than one office, whether the branch offices are assessed as the same entity or whether there is to be a separate assessment. When what was in challenge was a reassessment order for the respective assessment years, my lord. And the single judge sets aside the reassessment on the basis that I could not have treated the.
You file your submissions,
I'll file my submissions.
both of you.
Yes, my lord.
We just say that at the outset, Mr. But learner counsel for the appellant submits that the objection which has been put by the registry shall be cleared within how much time?
A week.
A week's time. Stop. Counsel for the parties to file their written submissions along with the judgment they want to rely on. Within 5 weeks, 6 weeks, list on.
A condonation may be allowed.
You have any dispute, the objection?
My lords, the condonation may be allowed, the stay may be dismissed, my lords, as has been done for the previous writ appeals.
Just say this, IA 1 of 23, this is an application seeking condonation of 183 days delay in filing the appeal for the reasons stated in the affidavit in support of the prayer for condonation of delay, and the learner counsel for the respondent has no objection. From the delay of 181 days is condoned, the application is disposed of. Okay.
May I give the connected matters, my lord? All can be posted together whenever your lordship.
Yeah, the connected.
My lord, writ appeal 893 of 20.
Are there any dates in those?
No, my lords.
You file a memo.
We'll do that. We'll do that. As your
Just give a date memo.
13/125.
Next.
My lords, the stay application, no orders.
We are not saying no. Want to withdraw the stay application?
My lords, your lordship may dispose it off because I've suffered a dismissal in the others, in the connected writ appeals.
So
My lord.
I'm ready for final arguments on.
just say that learner counsel for the appellant does not, as the appeal is being set out for hearing, it does not press this application.
My lords.
1 of 20, dismissed as not pressed.
My lord.
Next.
13/1/25, sir. Serial number 13, delete. 13.
Yes.
So filing a short list of dates, my lords, it's a short matter.
You're ready?
Please, my
Ready,
lords.
Mr. Shambi, you are ready?
Please.
Pass over. You come back.
Can I pass on copy of the submission?
Yes, we'll
So
just
that-
pass over the matter also. We'll take it up.
Yes.
14, government. 14.
Notes, serial number 14, I have some, although I've not done any work for this company, the promoters of this company are longstanding clients of mine. If the matter can be had about 2 days from now, as an exception, I'll request the department to brief another government advocate.
Okay.
I have a
Have a
conflict.
difficulty?
Yes, ma'am.
My lords, I'll take notice.
Yes,
on
see,
behalf of
be
the
notified.
respondents.
Yeah, I believe there is something pending before the NCLT, and we are seeking
Alright.
permission to, if it could be,
We'll have it when do you want?
my lords, in about 2 days' time, on Wednesday, as an exception.
Just Wednesday.
13.
And my lords, I may be permitted to take notice on behalf of the respondents.
We say nothing, ma'am. Let the council come.
13/11. Serial number 15, Shri Dilip. 15.
Lord, we have served the copy, my lord. They were on
You serve the copy.
We have.
On Have you got the 30th
of August 23.
Lord, I'm appearing on for the respondents, Lord, online.
Yes. Just say, is it admitted matter?
Not yet, my Lord.
It been admitted?
It's a writ appeal, my Lord.
Oh, sorry. Okay. Just file your submissions on this. Then a counsel for the parties to file their written submissions.
Right.
Along with the judgment they want to rely upon. Just see what is the issue.
My Lord, a very detailed order has been passed by the learned single judge. My Lord, this is against the rejection of a 195(2) application.
Yes. Let's see that. We'll just have it some other day.
Yes, my
File your
Lord.
submissions.
Yes, my Lord. We'll file submissions. My Lord, could I request your lordships to put it in the first week of January, my Lord?
We will give you a date. We'll give you a date. Submission be filed within 6 weeks. Then
Yes.
we'll give it.
6th of January, sir.
13th.
6th of January 2025.
My Lord, could I request for 13th instead, my Lord, if possible, if it's convenient to the court?
13th, sir.
13th.
13/1/25.
Oblige me.
Serial number 16, Srimati Sarita Kulkarni.
In the correct address of respondent, my lord, kindly 2 weeks' time may be granted.
You were to serve the other side.
Please, my lord, let's see.
Just say that notice, fresh notice be issued for service on the respondent returnable on.
20th January 25. 17, Shri Sushal Tiwari.
Pardon? The 474 days delay, what is have they explained it? The learner counsel for the respondent seeks and is allowed how much time? Ma'am? 6 weeks to file objections to the IA 1 of 24, which is an application seeking condonation of 474 days. Condonation of delay of 474 days in filing the appeal.
13/1/25. Serial number 18, Shri Bhargav Bhatt.
My lords, seeking 2 weeks' time to file the submissions, my lord.
You are ready to argue?
My lords, not today, my lords.
Why? Let's see, we'll just pass over, let us see.
Yes,
Okay?
my lord.
We'll just
Yes.
pass. Next.
19, Shri Ravi Raj.
My lords, this matter, my lords, registry has raised an objection regarding maintainability.
That's right.
My lords, it's covered. Your lordships may kindly dismiss my appeal, my lords, giving liberty to file before the appropriate high court. My lords, the Honorable Supreme Court, my lords, in the case of ABC papers, my lords, wherever the assessing officer has passed the assessment order, my lords, the appeal lies to that.
But why did it go to Chennai?
My lords, it was originally in Chennai, my lords. After, my lords, I think 2 years back, my lords, it was centralized to Bangalore. Case was transferred to Bangalore, my lords. That is the reason we filed it over here. My lords, we'll have to file it before the Madras High Court, my lords, as per the Supreme Court order.
You have to file before the Madras High Court.
Please, my lords.
But why did you file it here? then?
Because the case was centralized, my lords, to Bangalore. It
What
was
do you
transferred.
want? What do you want? You want to withdraw this?
Lordships may kindly dismiss it, my lords, reserving liberty to file, my lords,
No,
before
that-
the.
No, we will say, we don't mind also saying so, or recording it. It would be more appropriate, go to the Madras High Court.
Please, my lords,
Okay, very well.
my lords, only for your lordship's assistance, my lords, similar matters were disposed of, my lords.
Very well, it's all right. Just say this, just give those orders. This also, that was in Delhi.
Please, my lords. My lords, at that point, my lords, the Honorable Apex Court order was not available. My lords, this order,
Just say this, the challenge in this appeal is to an order passed by the ITAT Chennai. First, the registry has taken an objection on the maintainability of the present appeal. That's right. Where is the Chennai only, no? This.
please, my lords, assessing.
Full stop. In the noting the aforesaid submission, aforesaid position, the appeal in question is not maintainable in this court and accordingly is dismissed. The registry is directed to return the certified copy of the, no. Full stop. Suffice to state, just cut that. The appellant shall be at within liberty to file an appeal before the jurisdiction high court within an outer limit of 8 weeks. 8 weeks from today. So it is made clear that the time spent by the appellant before this court from the date of filing of the appeal. That is, when did you file it?
My lords, it was filed 26 September. My lords.
26 September 2024 shall be excluded for the shall be excluded for the purpose of limitation.
Lordships, to kindly say this, it's, my lords, appeal is not maintainable, my lords, in view of the Apex Court decision in ABC paper.
The appeal is not maintainable in view of the judgment of the Supreme Court in the case of Principal Commissioner
Please, my lords, versus
of
ABC paper.
Income Tax versus ABC Papers Limited. This is 2022 141 taxman.com 332. Just say that 2022 447 ITR 1. So this judgment says go to Chennai.
Please, my lords, wherever the assessment order is passed, my lords, appeal has to be filed before the respective high
And
court.
here the assessment is there.
Please, my lords, assessment order was passed by the Chennai SC
Right.
office. Your lordships will get.
And even the SSCs are in Chennai.
Please, my lords. Subsequently, my lords, last year it was centralized, my lords. The case was transferred from Chennai to Bangalore.
Okay,
Please,
thank you.
oblige.
Number 20, Shri Sanmati.
Which paragraph of Supreme Court you are saying?
My lords, para. It's para 31, 32, 33, my lords. 33 is relevant. Lordships will get
Very well, fine.
married.
So in any case, the Supreme Court says though that even as transferred in exercise of section 127.
Even other, it goes before the
That's
same.
right.
Court.
Till number 20.
Appear for appellant, no, there is delay of 119 days, my lord. And the respond.
Pardon? You have, in fact, last time it appeared the same submission was made. Who is the counsel? How can that be? You have informed them. If you don't want to pursue, then we'll go ahead with the appeal. Just say as a last opportunity, time is given to the respondents to put in appearance to a counsel. Re-notify on.
212. 21, serial number 21.
For the appellant in this matter, I'm filing the memo for withdrawal.
The learned counsel for the appellant has filed a memo which reads as under. Stop. The learned counsel for the appellant states that the appeal be dismissed or disposed of.
Dismissed or disposed of, whichever, my lord, as infectious, since it's infectious.
Disposed of as infructuous.
Please, man.
Stop, it is ordered accordingly.
Grateful.
22.
I am for the. Lords. Ex parte was challenged before the trial court under 9-13. That came to be dismissed. And an appeal has been filed before this, my lords. There was direction to deposit a decretal amount, entire decretal amount before the trial court, my lords. Since the petitioner is financially distressed, my lords, he can't arrange the funds, my lords. Matter may be disposed of, my lords.
Saying what?
Hearing on merits, my lords. Hearing on merits, my lords, the matter may be.
You don't want to deposit the?
Lords, he is in the financial distress, my lords. My lords, I have to file my objections to that applications, my lords.
For what?
On that directions, whatever they filed, my lords, it is an IA number 2 of 24.
No, but what
So-
will happen till the next date?
My lords,
What is
I
your
would
IA
undertake
number?
that I would not sell the property, my lords.
You will.
Please, my lords.
Which is your application number? It is 2 of 24. It's 2. Where is this? See, we say nothing on the deposit. They have not deposited, they have not deposited.
I would undertake, my lords. I would undertake with an
yeah.
affidavit. I'll file it before the registry. my lords.
The learned counsel for the appellant fairly concede that despite order of this court, that what, yes, show us the order sheets. How much you had deposit? Have you deposited
Well, it's-
anything earlier?
Please, my lords. 55 lakhs was deposited before the trial court.
How much?
Please,
56 lakhs.
Please, my lords.
And the balance was to be deposited in terms of this order, 4924.
Please.
Just say that fairly states that the balance amount as directed on 4/9/24 by order dated 4/9/24 has not been deposited. That's all, na? This is only 4/9/24 order.
Please.
The learner counsel for the respondent. This is both the respondents? No, there are many. One, two, there are two respondents. You appear for both. Presses IA 2 of 24, which is an application filed with the following prayers. What is the prayer? No, as
punish.
As with the following prayer, this would be tick to tick. I'll put a flag. A flag. The wherein first of the prayer as made in the application is either for a direction, to the appellant to furnish security, is to the extent that the appellant may furnish the security for the decretal amount, or an order be passed for attachment of the scheduled property stands in the name of respondent number 1. Appellant number 1. The suffice to state that the application incorporates the details of the scheduled properties. That's right, the details of the scheduled properties. The learner counsel for the appellant on perusal, have you got the application?
Please, minutes. I've got the application.
You have seen those scheduled
Please,
properties?
Please.
So we are taking your statement with regard to all the properties.
Please, minutes.
States that the appellants shall not alienate, dispose of, or create third-party rights with regard to the scheduled properties as mentioned in the application. Scheduled properties as mentioned in the application till the next date of hearing.
Please.
The statement is taken on record. Liberty shall be with the counsel for the appellants to file a reply to this IA 2 of.
Please.
Take the date.
4/12. 4/12. Serial number 23.
And serial number
Yes.
23, I appear for the appellant's counsel. The lordships may recollect, this is a matter where I had addressed in arguments at some length. I had restricted my arguments to the fact that initially, after a couple of rounds of remand, when this honorable court remanded the matter back to the income tax IT-80, I had submitted that the IT-80 ought not to have further remanded it, and it should have decided the issue itself. Now, my lords, I concluded by submitting that I will explore the possibility of reapproaching the IT-80 to see if the IT-80, your lordships may recollect, I had made a submission right at the end. Now, my lords, I'm instructed to submit that that application will be hopelessly time barred right now, so I'm not able to go back to the IT-80. Also, my lords, one thing that I had not submitted on the last occasion is that not just the aspect of whether the IT-80 erred in further remanding the matter, but whether those 4 criteria themselves are relevant to the scheme or are they outside the scope of the scheme is something your lordships may have to consider, which is why the first question of law, if my lords were to kindly see at page 43. That is something your lordships may have to consider, because I'll take my lords through the impugned findings. The first question, my lords, has it at page 43. So whether on facts and circumstances, so and so, the appellants erred in law and remanding the matter to the assessing officer for further inquiry as to the existence of unit-wise submeters for power and water connections, when no such condition exists under law for availing the deduction under section so and so. So, my lords, my respectful submission would be the tribunal relied upon an earlier judgment of the tribunal itself, which has attained finality. Now, that judgment really, although we relied upon it, was relevant for a particular issue as to whether a unit.
See, but they tell us one thing, Mr. Vikram.
Yes, madam.
Now, no, on the other two aspect, now it has been relegated.
No, that's what I'm trying to submit, Malas. As far as I think water is concerned, it's almost, right now, Malas, it'll be impossible for us to show that there is a separate water connection. Because at that point in time, 2006, 7, 8, 9, and 9, 10, separate meters were not given for each unit. And we would, as the developer, we would bear the entire water charges and then allocate it.
But that's the requirement in law.
That's what I'm submitting. There is no such requirement. In fact, even in primal projects, there is no such requirement.
Then you can argue everything there.
Before the assessing officer. No, but then my lords, I would respect
the remand is to the assessing officer.
Correct, my lords. Kindly see, my lords, if my lords were to kindly see the remand portion at page 71 running on to page 72.
Yes.
Paragraph 7.6, my lords. However, in the present case, the condition laid down in respect of serial number A and C is fulfilled. However, B and D are required to be verified as to whether the submission of the assessee with regard to securing the power connection, water connection, thereafter appropriation of the charges of each unit on the basis of submeters. Accordingly, we remit the issue for the limited purpose of verification of charges of power and water charges on the basis of submeters. So therefore, my lords, the assessing officer would only limit his examination to whether there are submeters or not. Now, if I'm not able to show water submeters, assessing officer would rightly reject my exemption. So therefore, my lords, this honorable court may have to answer the question as to whether primal projects actually required the submission of separate submeters even for water. Now, if the answer is no, then at least the assessing officer's examination will be restricted only to power and nothing more. And even otherwise, my lords may kindly see primal projects, although oddly, my lords, we ourselves relied upon it. Primal projects was a unique case, my lords, where all 4 floors of the developed software park in that case were all given to one person. There, the assessing officer denied the exemption, saying that you've given all 4 floors to one person. One of the conditions is that you should have 4 tenants and 4 units. Therefore, we're denying you the exemption. There, the ITAT took the view that unit is defined under the scheme. Unit doesn't mean a separate tenant. And the test to be applied is the functional test, which means whether each unit can function separately as a unit of its own, irrespective of who it is sublet out to. So here, my lords, if my lords were to kindly see just above the page I read, at pages 69 onwards, I've submitted a table which doesn't seem to have been...
unit is, I think that has been cleared by the ITAT.
Correct, my lords. If unit is cleared, I don't need to go any further. In fact, my own reliance on primal projects may be sort of self-defeating, because if these tables at pages 69 and 70 are accepted.
The issue is only power connection and water connection.
No, I would respectfully submit water connection, power, I'm saying even power may not be relevant, but assuming power is relevant, I may be able to show because there are separate subunits. But water, my lords, it's an impossible task for me to show because there were, I'm told, instructed to submit factually that there were no subunits. Therefore, I'll lose the entire deduction on a consideration which is extraneous to the scheme itself.
No, but you can still say so with regard to all units, there is no water connection or water.
Correct. Assuming I submit, no, I bow down. Assuming I submit that to the assessing officer, I ask myself, what will the assessing officer say? Assessing officer will tell me, tribunal told me to check A and B. You are not showing me B, I will reject your deduction. So therefore, my lords, your lordships may have to consider the first question of law, whether that B and D are even relevant or germane to the scheme itself. And oddly enough, my lords, I'll place it on record at a relevant point in time. The scheme itself defines common facilities to include power and water. So therefore, when the scheme itself says water and power are common facilities, was it, I asked myself, my lords, correct for the ITAT to say you should show separate? And primal projects also doesn't say that. My lord may kindly see primal projects.
Possibly we may agree on water, but not for power connection.
Power are we able to show? Power we are able to show, my lords. Power I'm told we're able to show. So if a lordship could clarify that if,
No, we say nothing. These are only, see, it's a very limited.
correct, Manoj, that's my difficulty. Now, in fact, I thought over this. My difficulty genuinely is this: if I go before the assessing officer in the teeth of these observations, the assessing officer, and I would respectfully submit, rightly so, would direct me to submit B and D, because that's what the direction to him is. If he looks at only B, he in fact is in violation of the ITAT's order.
See, your all pleas are left open. You are within your rights to argue insofar as your independent power connection, you are fine, you are confident that you will be able to establish.
Yes, Manoj.
Now then come, possibly you can argue.
Yes.
Unit is separate.
Yes, Manoj.
Electric connection is
Correct.
separate. Independent door number.
Yes, but we are able to show that. That's not an.
Insofar as water
Water.
connection is concerned, if it is a water connection which is common to all units, I can't show an independent water connection.
Then, my lords, kindly see, which is why, could I request my lords to kindly see page 72 once again, just the last sentence. Accordingly, we remit this issue for the limited purpose of verification of charges of power charges and water charges on the basis of submeters. Now, my lords, the question is, could the assessing officer then say that I will not look at water, I'll only look at power? He in fact will be in violation of this ITAT order.
Who appear for the revenue?
I think Mr. Tirumalesh, I'm told, my lords.
Who appears for the revenue?
Mr. Tirumalesh.
He's not there today. Has he come? Just call him, we'll pass over, let's see.
He could be online. Was it 2:30?
But why does this submeters reference was made? On what basis?
My lords, the whole issue is this. When I apply for this deduction, I have to get two clearances. One from the Department of, so the Ministry of Commerce and Industries, two from the Central Board of Direct Taxes, both of which admittedly I've got a clearance. Now, one of the conditions in the Ministry of Commerce and Industries notification is circular is this, that I have applied that I will have 4 units and that not more than one unit will be allocated to, not more than 50% will be allocated to 1 unit. Now, I have to satisfy the first condition. I don't think there's any issue. I have 4 units. The second issue, which is why the assessing officer relied upon it. Then the Commissioner of Income Tax Appeals, relying on my own case in 2004-5, said, I have held in favor of the assessee. Therefore, I will dispose of the appeal accordingly. ITAT also confirmed it. Then this honorable court, my lords, remanded the matter saying that the order is very cryptic. There are no reasons. Please look into the issue again. What the ITAT chose to do then is remand the matter once again, which this honorable court deprecated, saying, when we direct you to decide the issue, you can't send it back again. Now, once again, my lords, that's what I had submitted on the last date. But even leaving that aside, even if rightly so, the ITAT has remanded for a limited scope, I would respectfully submit in short, my lords, my issue is this, that the scope of remand is extraneous to the conditions in my scheme itself. Now, can I show it to the assessing officer? If it's an open-ended remand, yes. But in light of this remand, it would be difficult for me to.
Are you saying the scheme does not contemplate submeters to be shown?
Absolutely not. There is no mention of submeters at all. In fact, submeters is a.
How does this has come before the ITAT? Which is evidenced by the separate submitter. If you see page.
That, my lords, in all fairness, I have to submit. I'm told that the representative before, or the assessee representative before the tribunal submitted that we have submeters for power. Now, I think there's probably been a communication gap, and that has been construed to mean submeters for water and power. So there, the water aspect, in fact, the BWSSP regulations themselves, I'm told, my lords, did not permit for separate submeters at that point in time. Recently, I'm told each unit will have a separate submeter. But in 2006 till 2010, which is a relevant point in time, there was no provision for separate submeters. So even under the BWSSP regulations, it would have been impossible to perform. But yes, my lords, in all fairness, it was probably our mistake. We should have clarified that this submeter issue could be restricted to power, albeit the fact that, my lords, that there is nothing in the scheme. In fact, the scheme, to the contrary, as I was submitting, both power and water are under common facilities. And really, my lords, under the order in primal projects, what really the tribunal said in that order is this, that the scope of inquiry is limited to seeing whether each unit is functional or not. Now, how is it functional? That, of course, is left to the discretion of the officer. Now, this is, of course, now self-inserted, which says you have to have a separate submeter. But really, all that has to be done is look at each unit. Is it self-sufficient? Is it separately functioning? If the answer is yes, even if, as in primal projects, all 4 floors were sublet to only one unit. And one more aspect, Maharaj, there's this also seems to have not been argued, but this unit under the scheme is defined to mean a separate and distinct entity for the purpose of one or more state or central tax laws. So therefore, if I am able to show that my 4 tenants are separately registered under, say, GST or under the income tax law, that should suffice for the purpose of the scheme and nothing more. But that was not possible in primal because there was only one tenant, which is possibly why primal went on to the extent of saying whether each unit is functionally different or not.
Here also there is only one tenant.
4 different. That's which I'm saying. But if my lords were to kindly
And not separate units under one tenant.
Oh, kindly see, my lords, your lordship's question will be clarified. Page 69. There are 3 tables which are attached. Kindly see, the first table at page 69, assessment year 2006-7. iFlex Solutions has the 3rd column, ground floor, 1st floor, and a part of the 2nd floor. Then the 3rd floor is Transwork, and part of the 2nd floor also is Transwork. Then there is Invitrogen Bioservices on the 3rd floor and PSI Data Systems on the 4th. So of course, it's not, each floor is not, so part of the 2nd floor is given to Invitrogen, part of the 2nd floor is also given. So the test really is whether each of them can function as a separate unit or not. And as I was mentioning, unit is defined to mean whether they are for the purpose of different state or central tax laws. Here, I think if iFlex and Transwork and Invitrogen have different GST registrations, that should suffice. But in all fairness, again, that hasn't been considered in the impugned order. So really, in short, my submission is the remand order directing me to produce certain materials extraneous to the scope of the scheme itself.
I will take notice for the respondents.
Pardon?
I will take notice for the
You
respondents.
take notice, just say issue notice.
There's a delay also, Malabs. There is a.
How much is the delay?
I think 250.
No, just give a copy of the appeal to him.
We'll
He
give
will
a
appear now.
We'll give a copy.
Issue notice, Mr. Sanmati accept notice. Okay. Let a copy of the appeal paper book be given to him during the course of the day. Based on. Just see it, whatever is being argued, just have a look on the appeal also. Just give it.
Unfortunately, for 2004-5, they withdrew their appeals on the ground of monetary limit. Otherwise, we may have had a finding. Otherwise, we would have had a finding by now.
Right.
212,
Grateful.
serial number 24. 24.
May it please this court. My lord, there is a delay of 7 days in filing this appeal. The reasons for the delay are to be found at page 444.
Yes.
My lord, the disputes in this case revolve around the question of the extent to which deduction is allowable under section 80 capital P of the Act. And the learned tribunal by the impugned order segregated the interest into 3 different categories and addressed each of these categories separately. But the interest in my books of account are not so categorized, and there are 8 assessment years involved. And some of the, for some of the years, the books of account are even maintained manually. Therefore, it took some considerable time for the assessee to determine whether what the tax effect was and whether an appeal would be justified. At one point, on the advice of counsel, considering that the issue would recur, irrespective of the tax effect, the assessee was advised to file the appeal. This resulted in a delay of 7 days. The assessee is also a state government undertaking, and there are some internal processes required to approve.
Yes, for the revenue.
We'll take for notice.
Mr. Thirumale.
They issue notice. So and so accept notice. You appear for all, Mr. Sanmati? Just show him the appeal.
For all the respondents.
All. just say to file their submissions along with the judgments. We'll consider it on admission later.
Obliged, I have no difficulty.
Re-notify.
1612, if it is convenient to the Honorable Court.
We'll see that. Just see what is convenient.
1612.
Obliged.
Just give a copy of appeal to him.
Please.
25. Bill number 25.
Name for the appellant, my lords.
This is the same matter which we heard now.
Yes, my lord.
We'll
The matter
just
has been
pass.
heard at length, my lords. Yes, my lords.
We'll just pass over the matter.
Yes.
26. Shri Sanmati.
Is it transfer pricing?
Supreme
What-
Court remanded matter, my lord.
Shall we await?
Lordship, my respective submission is that let the matter be admitted, my lord.
We'll admit it. Huh?
2, 3, 4 only, my lord, I am pressing for.
In item 26, in all the appeals.
Your
See,
lordship, in
according
first.
to us, from 26 to 30, all are transfer pricing.
Yes, my lord.
That's right?
Yes, my lord.
Will that be a common, this thing, identical?
No, my lord, it may be admitted separately, my lord.
Separate, okay. Just say this. Admit the following substantial questions of law arises for consideration in this appeal. Don't take one, take 2, 3, 4. That's right? 2,
Yes, my
3,
lord.
4. At pages 10 and 11. Okay. Full stop. Just the counsel for the party states that appropriate shall be to await the outcome of the appeal which is being considered by a coordinate bench on an identical issue. If that be so, list this appeal in due course.
Please, my lord.
Now, which is the next one?
Next one is also same, my lord, 2, 3, 4 questions.
Next is also 2, 3.
2, 3, 4, my lord.
Same, ma'am. 2, 3, 4, na?
Yes, my lord.
Okay.
28.
Same order.
28, one question only, my lord.
The solitary question?
Yes, my
Only
lord.
one question?
Only one.
Same one question. Then 29,
Here also one question only, my lord.
one question. 30,
Here also one question only, my lord. First question.
and all we will have it in due course.
Yes, my lord.
31.
This matter, my lords, arise out of a penalty order. Lords passed under section 271, 1C. The lordships may kindly refer to page number 34 of the tribunal order.
Yes, Mr. Shankar.
My lords, this appeals has to be allowed, my lords, only for one reason. My lords, the tribunal has relied on the quantum appeal, my lords, which was in the favor of assessee, my lords. We challenged the quantum appeal before your lordships in a 260. My lords, this honorable court, my lords, allowed revenues appeal and remitted matter back to the tribunal for consideration afresh on merits. My lords, the entire assessment was knocked off only on validity of search, my lords, regarding search was on an invalid person. So the entire addition was knocked off on that, my lords. Against that order, my lords, we came before your lordships. Your lordships allowed our appeal. My lords, against that order, my lords.
There are 4 appeals, 5
Lords, it's
appeals. Yes.
on the partners, my lords.
Respondent in this case, if I may be allowed to make one submission here.
And we'll just come back to you. Just 1 minute.
Right.
Yes. We want you to file your submissions. File your submissions. They're fine. Now you are appearing in which matter, ma'am?
Your Lordship, I'm appearing in item number 31, 31.3 and 31.5. Your Lordship, actually in this case, a review petition was filed before this honorable court. And that review petition was in respect of the order imposing tax. Because Your Lordship, in this case, what had happened was that the ITAT had quashed the assessment proceedings on the ground that the search was not valid, against which this honorable High Court had set aside the ITAT order. But the honorable ITAT had not adjudicated the matter on merits. So therefore, Your Lordship, we had moved a review petition, and this honorable court, by order dated 31st October 2022, had taken note of this fact and had granted liberty to mention after the disposal of the review petition. But in the meanwhile, Your Lordship, what has happened is that the review petition has been dismissed for not complying with the office objections. And we are filing an application for recall of that to revive the review petition. It has been dismissed only for non-compliance of office objections, Your Lordship. So, Your Lordship, my only request is this matter may be adjourned today because we are going to revive the review petition by filing an appropriate
Your Lordship's
application.
permission, I'll read only one para, my lords, at page 34. Page 34, para 4.
Appeal.
My lords, in the first appeal, my lords, ITA
31.
712 of
712.
2019.
Which number? Which page?
My lords, page 34, para 4. My lords, this is the tribunal order. My lords, since, may I read, my lords? Since the assessment orders on the basis of which the impugned penalty orders have been passed have been quashed by the tribunal, while its order referred above, the impugned penalty order shall not have independent legs to stand on its own. Accordingly, we find merits in the submission of learned heir of the assessee. We notice that learned CIT appeals has cancelled the penalty on reasons cited above. Accordingly, we do not find any merit, infirmity in the orders passed by the learned CIT appeals. My lords, tribunal has simply said, my lords, because the assessee has succeeded on merits, my lords, the penalty orders fail is what the tribunal has said. My lords, now we've succeeded before your lordships. My lords, the matter of my lords, it's pending before the tribunal. My lords, the same principle applies to us also, my lords, because now we've succeeded before your lordships. My lords, these appeals has to be allowed. My lords, because the matters were never considered on merits.
Now a similar order was set aside.
Please, my lords, I have our High Court petition. My lords,
Which is that order she is referring to in 31.3 and 31.4?
Your Lordship, 31st October 2022, if Your Lordship may see the order passed by this honorable court, 31st October 2022, this says that Shri A. Shankar, learned advocate, senior advocate for the appellants, submits that order imposing tax in respect of same assessee and of the same assessment year is under consideration in RP number 1000036 of 2020. The orders impugned in these appeals pertain to penalty proceedings in respect of the same assessment year. Let these appeals go out of the list with liberty to mention after disposal of the review petition.
The review petitions are dismissed. I have the
For only for non-compliance of office objections, Your Lordship, not on merits.
Even otherwise, my lords, on merits.
We are seeking recall of this order, Your Lordship.
My lords, on merits. My lords, please. My lords, we've succeeded on, my lords, on quantum. My lords, this honorable court has directed the tribunal to consider on merits. My lords, now same thing applies, my lords. Wow.
You are right. You will still have that plea available. You are not saying so.
My lords,
see, tell us one thing also. You also sit over the matter, the objection. You don't clear the objections. What will the court do?
My apologies for the same, Your Lordship. The local council couldn't pursue it. Actually, Mr.
We don't want A, B, C counsel. We say the appellant or
Yes,
whosoever
Your
is the
Lordship.
litigant.
Your Lordship, the only problem was that the counsel who had filed the Wakalatnama, he was appointed as a standing counsel. So he couldn't pursue this matter, Your Lordship, because of which there was some confusion. Now, Your Lordship, we are actively
And
pursuing.
when was the review dismissed?
Your Lordship, it
When
was
was the review
dismissed on
dismissed?
6 June 24, Your Lordship.
Then where are we today?
Yes, Your Lordship, we are in touch with the local council and we will
Very
get it. I,
See, that's not the purpose. Purpose is to file an application at the earliest. You don't have not
earliest,
done
Your
it.
Lordship. If it's not done, we will do it at the earliest, Your Lordship, within a week.
My lords, one submission, even
Yes.
otherwise, my lords, review petition will, my lords, against the quantum appeal, they filed a SLP. SLP also is rejected, my lords.
Against which?
Against the main order,
Pursuant
my
to which
lords.
we had filed the review
1
petition,
minute,
Your
ma'am.
Lordship.
Just 1 minute, please. Not like this.
Against the quantum appeal, my lords, which we succeeded before your lordships, against that, my lords, they challenged before the apex court. My lords, the SLP is rejected. I have that order also, my lords.
Whose SLP rejected?
Assessee's appeal.
Assessee appeal was rejected.
Please, my lords.
So what will happen in review?
My
Just see
lords,
what is the order, show us.
it says. That's when
See, we want to, there are 5, 6 appeal, we want to see the facts of each case. Withdrawn.
It's
not withdrawn.
Lords, now.
Okay, let's see that. We will give, you file your submission. We want a brief submission so that at least we are clear on facts.
Please.
We say nothing about her submission. Just say that re-notify these appeals on, just give it after 3 weeks. The counsel for the parties to file their brief note of submissions in all the appeals.
9/12.
But there are separate appeals, numbers are separate.
Please, my lords. It's a common order.
Okay. No, we don't want to limit it. Whosoever appealing, suppose one is the appellant there in one appeal, the other maybe you are the appellant in the other appeal. You are respondent. Then you file your common appeal. But the parties, the respondents are common?
Different, my lords.
Okay. Very good. You just file your, this thing, we'll have it on 9/12. Next.
Obliged.
Oh, just give a date convenient to him.
16/12.
16/12.
Madam, 16/12.
Obliged.
Serial number 32 urgent, 33.
My lords,
Serial number
33, my lords, it's already admitted, my lords, again, it's, I think it's posted by mistake for. admission.
32 admitted? No.
33, my lords.
33 admitted.
Please.
When was it?
Hold on. 3rd January 2023, my lords. I think by mistake it's.
Then file your submissions.
Please.
32, 33, just written submissions be filed within 8 weeks, list on, just target. What about the next one? What is the counsel's name? Mr. Dilip? Mr. Dilip, what is 34?
My lords, it's a transfer pricing matter, my lords, comparables.
Is admission, has it been admitted?
My lords, it's not it, my lords. 1, 4 and 5 question arise, my lords.
1, 4 and 5?
Please.
Ma'am, you appear for the respondents? Just 34 there, say this, admit the following questions of, substantial questions of law arises for consideration in this appeal. This would be, it's not transfer pricing.
My lords, it's comparable, transfer pricing, my lords. It is,
Shall we await?
please, my lords.
Okay, just say this, you said 1, Which
1,
one?
4 and 5, my lords.
1, 4 and 5. And the same order, you know? Coordinate bench, 1, 4, 5. What about the
35.
35?
35.
Is it the same transfer pricing, Mr. Sanmati? Comparable, not comparable? We have it separately.
Please, ma'am.
Is it admitted?
Not yet admitted.
Just, tell us. Proceedings. So we don't admit it. Just say counsel for the parties to file their written submissions. Along with the judgment they want to rely upon within 6 weeks, this term.
6/125. Case number 36.
What is this?
Your
Is this
Lordship, in
transfer?
this case, my lord, the assessing authority has adopted a value of the property on the basis of the developer's statement, my lord. But the tribunal has taken the guidance value, my lord, by relying upon the decision of this honorable court, my lord. In the case of CPC Logistics, on the ground that section 50D came to be applicable in respect of subsequent assessment years. For this assessment year in question, there was no provision. When the rate was not determinable or ascertainable, the guidance value has to be taken into consideration. That is the decision of this honorable court in CPC Logistics. The decision has been taken note of and held in favor of the assessee, my lord. And also one more decision is also in the case of Srimati Sarojini M. Similar view has been taken by this honorable court, my
So
lord.
what is your submission? This should follow them. Yeah.
Yes.
Vishada, just show us those.
Two decisions. One copy, one more second. One more, 2 seconds. Your Lordship, another set, my lord. Same. They need to be the addition. Sarojini and the PPC.
And this assessment here is which one?
Now, this is for the assessment year, my lord, 2010-11, my lord.
Earlier to 13. There are two judgments you have given, no?
Your Lordship, two also on the same point, my lord.
CPC Logist, both are CPC Logist.
Your Lordship, one more decision copy I have given. Sarojini. Sarojini.
But I think you have given 3 copies of CPC Logistics. Did the tribunal follow these judgments?
Yes, my lord.
They have followed these judgments. Yeah, they have reproduced the whole of the order.
Yes, my lord. Paragraph number 28, page number 37, my lord. By following this decision, it has been held in favor of the assessee, my lord.
Para number?
No, para number 28, page 37 of the appeal memo, my lord. After the extraction, my lord.
Just say that, so we follow this,
Yes.
reject it. The appeal has been filed challenging the order of the ITAT Bangalore, ITAT B bench Bangalore. In ITA number, how many were there?
One matter, my lord.
What is this?
Your Lordship, the other cases, my lord, it has been held in favor of the revenue, my lord. That is not the subject matter of this appeal.
Just come to page 12. One is cross objector. What happened to that? It has been against that. You have not challenged it. Filed in ITA number 54 Bangalore this /Bangalore /2010-20 for the assessment year 2010 and 12. The appeal was filed by the revenue. Suffice to state that cross objections were also filed by the respondent HUF. The challenge oblique objection were primarily against the order of CIT appeals -11 Bangalore dated 14/10/2019 passed for the assessment year 2010 and 11. To stop, the ITAT has by relying upon the judgment of this court in PCIT versus CPC Logistics Limited, ITA 653 of 2016 has dismissed the appeal filed by the revenue. Where does it say about the objections? Page? No, where are the objections rejected?
Your Lordship, para 29, my lord. CO by the assessee or dismissed.
No, but there, it sufficed also to say that the objections filed by the SSC were also rejected, were also dismissed. Stop. On the appeal filed by the revenue, the tribunal, the ITAT has the ITSC having relied upon the judgment of this court in PCIT CPC Logistics Limited, and we have been informed that a further judgment of this court in the case of Principal Commissioner of Income Tax versus Srimati Sarojini M. Kushe, PVS BDs Private Limited. This is 2000 ITA number 475 of 2016, decided on 1st December 2021. Also decides the issue in favor of the SSC. Have they been taken in appeal?
Your Lordship, I verified it, my lord, because there are no records found in the website, my lord. Maybe due to the low tax effect, it might not.
These are low tax effect.
Maybe, my lord, because I could not ascertain completely, my lord.
But full stop. He states, Mr. Sanmati states, though he could not ascertain as to whether these these judgments were taken in appeal, he does not dispute the issue which fall for consideration in this appeal.
Yes, ma'am.
Are covered by the judgment of the PCIT versus CPC Logistics Limited Supra. Full stop. If that be so, the appeal, if that be so, no substantial question of law arises for consideration in this appeal. The appeal is dismissed. Again, the appeal of the revenue is dismissed in favor of the SSC. That's all.
Yes, my lord. Your lordship, one submission. Question number 2 does not arise for consideration for this case, my lord. Only 1 and 3, my lord.
Okay. These are no substantial questions of law, 1 and 3, just say that. 1 and 3 does not arise for, so the substantial questions of law, it's 1 and 3 does not arise for consideration.
Your lordship,
No,
1,
no,
3,
no,
2
are
does.
without merit. Just say that. Are
Yes,
without.
my lord. 1 and 3 only, my lord.
1 does not arise for consideration.
Your lordship, 1 and 3 arises for consideration.
2
but
doesn't arise.
2 doesn't.
Shall we record your submission?
Please, my lord.
Huh?
Please, my lord.
Say, Mr. Sanmati at the outset submit. It's only the questions of 1 substantial questions as framed at serial number 1 and 3 of the memorandum of appeal, which arises for consideration in this appeal, and not 2.
2, my lord.
Okay,
Please.
thank you. Okay, very good. Yeah, no, it's all right. It's a learning for me also. This issue, the appeal has been filed with this, the following substantial questions of law. Shall we say arises, or shall we say that proposed?
Raised, my lord.
Raised by the appellant. Appellant revenue in this appeal. Say 1 and 3. Okay. Then thereafter our original order.
Please, my lord.
So that we have said so.
Please, my lord.
Thank you.
Please.
37. Shanti Varma. 37.
Lord, it's a din matter, my lord.
Yes.
My lordship may kindly have it on 16th, my lord. Din matter.
It didn't matter. What are the facts here? Is it, did you have you generated the DIN?
Lord, I'm not aware, my lord. I know it's din, but it's.
What do you
My
say?
colleague's matter, my lord.
Not on the date when we will have it on the same day, ma'am. Let's see that.
16 from
16th.
38. Viraj.
My lord, transfer pricing matter, my lord.
Yes.
Page number 9. Question of law, my lord, 1 to 8 will come.
Just say this, the 1.
1 to 8.
Which is the number, ma'am?
38, sir.
Just say admit the following questions of law, substantial questions of law arises for consideration. Just, which are the pages?
Page number 9.
Is it 47?
30.
30.
Yeah, 37.
Page number 9. They say that the learner counsel for the party submits that as an identical issue is being considered by a coordinate bench of this court, to await the outcome of the said appeal, the matter be adjourned in due course. It's ordered accordingly.
39. Raghuram.
My lords, 39, I beg to appear, my lords, virtually.
Yes.
My lords, these are 39 and 39.1 are two writ appeals, my lords, arising from a common order. My lords, the short issue in this is that my lords are aware that we are supposed to pay advance tax in 4 installments over the financial year. During this financial year, which we are concerned with, financial year 16-17, I was undergoing an amalgamation. My schemes were already filed, which were pending adjudication. Therefore, I anticipated and estimated my advance tax to be a loss because my total income would have been a loss. I did not pay advance tax. Now, my lords, the short point is, can the department force me to pay advance tax? There is, my lords, section 210 of the Income Tax Act, which states that the department can issue me an order and I can then file a form 28A as per the rules. That should be the end of the matter, because if I'm shortfall on advance tax, I am liable to pay interest under 234B and 234C, but I can't be forced to pay advance tax. Now, the learned single judge in its order, while noting the judgments of the Supreme Court in Marshall and Sons and etc., that when the amalgamation is pending, the amalgamating entity carries on the business as a trust of the amalgamated entity, says because the learned judge says that since the scheme got sanctioned only in January, which is towards the end of the financial year, therefore you had the liability to pay advance tax for the earlier period. So, Malaj, two short submissions which I have in this matter, and I'll Malaj take Malaj through those judgments. That once I file a form.
Yes.
Yes.
We'll just pass over. We'll just pass over the matter.
Please, Lord.
Pick up the name, we take the name of the bench.
Paso. Serial number 40. Serial number 40.
We appear for the in this matter. This issue relates to Miller's partnership dispute Miller's. There were 3 partners Miller's. The respond number 3 was hosted by other 2 partners Miller. That issue is pending before the arbitrator. During the pendency Miller's, both the fractions of the partners Miller filed application before the GST authorities to give them Miller credentials to log in and pay taxes Millers. In fact, the present appellant.
What happened to the arbitration proceedings now?
Still pending Millers.
They are going on.
Please, Millers.
No, everything can't be worked out there.
Nothing has, so far nothing has.
My instructions are arbitration. Of course, I was asking the state.
Everything need to be worked out. You have 17, everything you file it there.
Please.
Once you are before arbitrator, why these proceedings here?
What happened, Millers? Lana single judge has given a direction to Millers GST authorities to give credential to respond number 3 Millers, who is a hosted Millers partner. We were also asked to Millers cooperate with him. Therefore, we filed writ appeal Millers, though 2 directions are stayed, and Millers also.
Can't there be anything worked out before the arbitrator?
There were multiple negotiations, Millers. As on today, there is cross-examination going on.
See, to be very frank,
please.
Once proceedings are there before the arbitrator,
please,
how can an appeal also be maintainable?
No,
everything must go there.
My respectful submission is, Millers. Let this Millers interim arrangement is there. Let it be pending, Millers. Let credentials with the respond number appellant Millers.
What the direction? What the learner single judge has?
Not single judge Millers. This court has given direction Millers in the interim order. That will continue Millers, subject to Millers outcome of the arbitration proceeding. 18.1 is the interim order. Which is
So Fanindra, it's like this.
Lord.
Parties are there before arbitrator. How can there be a parallel proceeding before the court? Everything, you have 17, you take recourse to 17. Any interim order you want to ask the arbitrator. Everything, he can work out everything.
But not against the department, that's my response.
Pardon?
Not against this department, my lords.
He can put an obligation of either one of the parties subject to outcome of arbitration proceedings.
Please, my lords.
That he can do.
Please. My lords, this court can, my lords, subject to what my lords says, my lords, can give directions as on today, what is the arrangement made by this court, my lords.
Right.
That will continue. Subject to my lords outcome of the arbitration.
Subject to outcome, what do you say on this?
Lords, the second respondent was directed to create a credential because my lords
are right. But
That's
that
been
order,
done.
did that order of the learned single judge implemented? No. By the time you came to this court,
Please,
it's modified.
Please, my lords. Modify the effect that today I have credentials, my lords. I am the one who is running business. I am filing my return, my lords.
But there is no default at least at your end to the government.
No, my lords.
At least they should also, my lords, what had happened, the learned single judge had said, because I was having the credentials as a partner, I should cooperate, they should cooperate. What they give, I'll only have to upload it to the GST portal, my lords. Now, today, if they do it unilaterally without even me knowing what's happening,
That's right.
then, my lords, ultimately GST authorities will come against me if I succeed also before the arbitration.
There is
That also
there's
they
additional
should have
background,
it.
my lords, to it, my lords. He's running, my lords, parallel, my lord, business
That is
with a
it.
similar name.
Possibly that's the reason why this court had modified the order.
Please, my lords.
So you think over it.
Please, my lords.
Will it, whatever directions, now you are paying the GST,
Please, my
but
lords.
he has an apprehension.
Please,
Could you work out that apprehension before the arbitrator? Arbitrator is seizure of the proceedings.
please, my lords.
He is holding the proceeding day to day.
Please, my lords.
Or at least he is holding the proceeding.
Yes, my lords.
Work it out before him.
The main issue of ousting one of the partner itself is the, my lords, one
that's
of the
it.
issues framed there.
That's the substantial issue.
Please, my lords. If that is answered, everything else.
Work it out everything insofar as the government dues are concerned of the statutory authority, you are paying it.
Please.
In what manner his interests need to be taken care of, that arbitrator will look into it.
Please.
That's how you have to work it out. To be verifying, we don't see. So please, we'll have it after 2-3 days or 4 days next week. Think over it and come. What do you want to say? That's how. See, once then arbitration proceeding, GST, they are not before the
In fact, they interfered in the form of, my lords. One of the officers, my lords, interfered and said that only that person, only respond number
That
3
is
can
not
file a return.
interference. Their mandate was, my lords, since I had a
protect
mandate
revenue.
to upload, they only said that we can't, they went unilaterally to the GST authorities to change the mandate of who uploads the GST returns. They said.
The person who is running the business, my lords, he should upload, my lords. Otherwise, the third party who is not.
Can't this issue be sorted out before the arbitrator?
Arbitrator can give directions to both the parties.
Liability.
But this arrangement itself can be continued, my lords, because there will be fresh proceedings before the arbitrator. Arbitrator has proceeded, my lords, issues are framed. Now arbitration, must have cross-examination going on. At this stage, my lords, section 17 application would be, my lords, little difficult to, my lords.
We don't know in what manner you want to seek any interim placement. That's for you to work it out. Now, but insofar as the statutory authority, they say we are concerned with the dues. Who gives, the firm gives, who give, you give or he gives, doesn't make any difference. Interstate dispute between both of you has to be worked out by the arbitrator.
Please.
That's all.
And I've given him the login. Subject to what your lordship said, does anything survive before this one?
No, we are on a basic issue is because ultimately the learned judge has referred the parties to arbitration. So it's only part of the direction which is subject matter of the appeal. So just think over it. We'll have it next week. Okay?
Please.
Just say re-notify the matter next week.
2511. 41 urgent, 42 should be late.
42 and 42.1 appear for the respondent in both matters. 42, there's a delay of 435 days. We filed our objection. We fixed on 25th November, when the senior counsel is briefed.
Just say that objections be filed to IA 1 of 23.
Already filed. Madam.
Already filed? Just cut it off. Just re-notify.
2511.
Achha.
43. G1 Niralgi. 43.
Just pass over.
44. 44 government.
I appear for the respondent. It's a revenue appeal, my lords. I appear for the respondent.
This is 43, na?
44.
44. Yes.
The application of the writ petitioner for refund of the service tax is rejected.
There's a continuation of delay application, my lords. There's a continuation of delay application, my lords, that may first have to be looked into, my lords. What are the reasons which they have assigned? April order, my lords. They filed it in the month of August.
Yes.
My lord, delay of 64 days, my lords, is explained in para 2 of the affidavit in support of the application for contention of delay. But order of the learned single judge is dated 18/4/2024. Then, my lord, the certified copy, my lord, was applied on 19/4 and received on 6/6/2024. Then, my lord, it goes along with the opinion of the government advocate. Then, my lord, they have to seek the order from the law department. Then the law department is issued a GO on 24/7/2024. My lord, the appeal is filed. It has to be drafted. These are the reasons, my lord, we have given, not much of delay. And there is no negligence on the part of the appellants in filing the appeal as such. So delay can be condoned.
But is there any liability under the GST?
Yes.
Huh? But there is a finding on that by the learned judge.
But in para 6, my lord, the learned single judge gives a finding as though the order of the proper officer is unreasoned, cryptic,
Forget that, but in any way, that's the basis, but para 7 is also the basis.
Para 7, my lords.
So if there is no liability, why should the money be with you?
No, my lord, whoever is entitled to seek for refund, my lord, can apply and seek. Here, my lord, section 54, my lord, contemplates that the application for refund has to be filed before the expiry of 2 years. My lord, now the tax, my lord, is paid is on, my lord, 1/8/2017, annexure B, that is at page 70, my lord, typed page, your lordship will see. The vendor is not the petitioner, vendor is, my lord, top, Mavin switch gears and control, with whom, my lord, the respondent petitioner had a contract with the supply of them, which has to be done within 4 months. But 4 months, my lord, would have expired in 2017 itself. Nothing prevented even the petitioner assumed that any person can make an application for refund. He could have. But they had their own disputes. But the application, my lord, is filed only, my lord, on 5/7/2021. 5/7, that is beyond, my lords, 2 years. 2 years.
When was the tax paid?
But tax paid, my lord, is on 1/8/2017. That is paid, my lord, that 70 or also get the tax.
Did you file any objections before the learner single judge to the writ petition?
There's a consent
But
order.
there was no opportunity to file, my lord. When, my lord, matter sometimes, my lord, comes up for preliminary hearing, then they would, court, my lord, would hear the wicket. Probably there was no.
Let's see your appeal. What are the grounds you have taken?
My lord, we have, my lord, stated. My lord,
How do you challenge the finding that there is no tax liability?
No, my lord, there was no supply, my lord, as far as refund is concerned, my lord, there is
Exactly the
no
point.
objection as such. Because goods were not supplied, so therefore, the vendor, my lord, who has paid the service tax is entitled to seek for refund. And we are not on that, my lord, but the, my lord, when the statute, my lord, prescribes certain procedure to be followed, especially for refund, my lords, then, my lord, the applicant, my lord, who seeks for refund of the amount has to file the application as contemplated. But here section 54, you kindly see section 54, my lord, within 54, 2 years.
So your only submission is, it is not, it's beyond time.
Beyond time, and my lord, the application itself was not, my lord, supported by the documents required, prescribed under the rules. My lord, rule 89 of the rules, read with rule 92, my lords, specify, my lord, what form to be applied, what documents, and all the details have to be furnished. No, nothing. My lord, even the proper officer, my lord, has not passed a cryptic order. He was given an opportunity to show, my lord, kindly see annexure D, my lords. Before passing the rejection order, my lord, that your lordship will get at page 74, after quoting on what ground the applicant is seeking for refund, 74, submission of the taxpayer is taken on record. However, the eligibility accounts of refund mentioned under section 54 is not established from the taxpayer submission. You are hereby called upon to show cause as to why your refund claim to the extent of the amount such and such should not be rejected for reasons stated above. Reason is given, but he does not file any objection or he does not show cause why application cannot be rejected, how he is entitled, he doesn't demonstrate it. Therefore, my lord, annexure E, my lords, the 6/9/2021 order is given. Not quoting, my lord, falling under section 54. What is wrong in it, but when the statute prescribes certain procedure, authority has to follow that procedure. Authority cannot go out of the way to consider the application. Any application has to be considered, we are relying on 2 judgments.
Yes. What do you say? Why after so many years?
That's 3 reasons, 3 issues, my lords, the submissions of what senior has made. Number 1, my lords, limitation was never the issue, which even the department had raised, nor did we answer, my lords.
Where?
In the writ petition also.
There was no opportunity to take place. That's what he's saying.
No, my lords may look at the impugned order. The impugned order is written as a consent order. My lords may look at the impugned order at the last part.
That shows that.
This entire matter, my lords, came up twice. The second time they argued at length. They can never go on to say that, my lords, that no opportunity was ever given. The only ground of contention before the court was that section 54 ought to be followed and it's not been followed. My lords, section 54 to be strictly followed, my lords, the transaction has to be understood, my lords. I enter into an agreement or I give a work contract to a supplier for in 2017 by advancing 16 crore 34 lakh 19,943 rupees, which is including GST.
You do one thing. You have anything to say on condonation?
That's on the condonation.
You file reply on merits, your affidavit on merits.
Yes, my lords.
On the appeal.
Yes,
so that we have the stand of both the parties, then we will decide.
Yes, my lords. We'll do that.
Okay.
Condonation, my lords, the reason why I'm insisting that, my lords, the condonation should not be allowed is the reason being, my lords, the order is passed on 18th of April 2024, my lords. The opinion goes by the same advocate, my lords.
64 days. And the government only filing after 64 days is never
That's
thought of.
after being a consent order.
Yes, that we will look into. That we will look into. It's a consent order, surely. Okay. Just say this is an IA 2 of 24. This is an application seeking condonation of delay in filing the appeal. 64 days delay in filing the appeal for the reasons stated in the affidavit in support of the application. In support of the prayer for seeking condonation of delay, the same is allowed. The delay of 64 days is condoned. Application disposed of. Notice on the appeal. So and so acts of notice. Just say that objections to the appeal be filed. How much time?
That's a week's time. That's
2 weeks time to file objections. Rejoinder be filed within 2 weeks thereafter. We notify the appeal for hearing on. Yes, sir.
1612. 45. Yes, Venkatesh.
Yes, Mr. Dutt.
Yes, my lord, this is for appeals. There are 5 appeals actually.
Yes.
These relate to, my lord, the assessment years of 96, 97, 97, 98 and 98, 99. Now, my lord, there was a contract, my lord, we had, as Jindal had set up a power plant where we had utilized the services of a foreign company, US company called Riol. Now, there were 3 aspects, there were 3 different contracts. The in-country, my lord, work was done by 2 entities of Riol, where there is no dispute about tax. Tax has been paid.
How long you would take in total?
My lord, what I was suggesting, subject to what my learned friend says, my lord, as far as the base tax appeals are concerned, there are 2, my lord, 2 penalty appeals. Now, in the penalty appeals are their appeals because ITAT is held in our favor, saying that because there was reasonable cause under 273B, therefore, no penalty is leviable. Now, they have filed a 1-page, my lord, appeal, and the ground, only 1 ground is raised. And that ground I will show, my lord, I will not take more than 15 minutes on the penalty appeal. I will show that that ground is based on a factual, my lord, misconception, because, my lord, the only ground is there, my lord, they had done a survey on 17 December 1997. Before the survey, my lord, we had initially in 96, for the assessment year 96, 97, we had initially, my lord, deposited TDS, deducted TDS and deposited. Thereafter, my lord, we got opinion. The Riol got opinion from a law firm, Singhania and Company, saying that this is not exigible to tax. And my lord also got an opinion from the chartered accountant, Lovelock Lewis, saying these all services were rendered from abroad. Therefore, there is no exigibility of tax. Therefore, no question of deducting any TDS. They also filed, Riol filed an application under section 245Q before the authority of advance ruling, seeking a determination whether there is any exigibility of tax. Unfortunately, on 30th September 1997, the chairman, my lord, at that time of the authority said that due to personal reasons, I cannot hear this case. We also, my lord, Jindal filed a 195(2) application, an NOC, in which, my lord, we sought permission to give payment and sought, my lord, a determination whether it was equal to tax or not. That determination came on 19 December. But 17 December is there. That application was filed in August, 27th August 1997, before the survey. All these opinions, the opinion of Singhania is 38th May 1997. The opinion of Lovelock Lewis is before that. My order of 30th September by the AR saying we will not hear due to personal reasons, all before survey. And Lord, on 19 December, when we get the NOC and they say, no, you have to deduct on 1st January and 5th January 98, we deposit the whatever was the, my lord, TDS amount.
But how long will...
Now, no, I'll just take 5-10 minutes. Now, their only ground is that if you see there, one ground in the appeal, that it is not reasonable. There is no reasonable cause because what you did was, what was done was after the survey, all these opinions have been taken. It's factually incorrect because that ITAT order is very clear. We have also placed the opinions, etc. They're all before the survey. Their ground is there is no reasonable cause because after we did the survey on survey date is 17 December. After that, all these activities have been done, which is factually incorrect. And my lord, the law is that unless there is a contumacious conduct or there is some malafide, penalty cannot be, my lord, imposed. There is Supreme Court judgment saying that if I reasonably bona fide believe that there was no exigibility of tax, and in this case, my lord, it is shown by all the opinions, etc. And attempt was made before the AR. All attempts are made. Therefore, my lord, ITAT comes to a conclusion that this is not a case for penalty. Now, my lord, there is a Delhi High Court division bench judgment also saying that this is a matter of fact. There is no question of law because, my lord, in appeal, this second appeal is only on a substantial question of law. So, my lord, my I will not take, though it's his appeal, I will not take more than 10 minutes to show, my lord.
These need to be heard together, no?
No, my lord, I will, my lord, as far as the base tax is concerned, there are two issues. One, my lord, subsequently, my lord, what happened? There was a judgment of this honorable court on 16th March 2009. There they said that relying on a Supreme Court judgment saying that since most of the services, all the services relating to technical aspects were outside India, that portion is not taxable. We also had, my lord, some overall responsibility for which some payment was given. So two portions they said is taxable. One portion, major portion, about $14.5 million is not taxable. My lord, after the judgment came in 2009, 16 March 2009, 2010, my lord, they amend by Finance Act of 2010, they add an explanation to get over this judgment and, my lord, also file an SLP. The Supreme Court, my lord, in the assessment year for the case relating to assessment year 96-97, give liberty to them to seek review. 97-98 is kept in Supreme Court, which is majority of the amount is 97-98, almost about 16 crores or something out of 20 crores total TDS. Supreme Court, my lord, it is dismissed in default on 5th December 2017. So it becomes final, that order of 16 March 2009. Now, as far as, my lord, the base tax is concerned, there is a recent judgment of the Supreme Court saying that if you do a retrospective amendment, because that amendment of 2010 is from the year 1976 with effect from 76. Then as far as the liability of the TDS deductor is concerned, there is no liability because he cannot be, you cannot assume that he will do something which is impossible, which was not in the statute. As far as the liability of the pay is concerned, that is real. That liability may be there depending on whether it is covered by the amendment or not. But as far as the liability of the deductor is concerned, there can't be any liability. And that judgment is 2022, my lord. I had pointed out also earlier. If your lordship sees the order of 20th November, it was pointed out. My learned friend said it is pending review in Supreme Court. That review has also been dismissed. So, my lord, I am relying only on that judgment just to make things, my lord, simple. On the basis of that judgment, there is no question of any liability as far as we are concerned based on a 2010, my lord, amendment. And as far as, my lord, the penalty is concerned, as I said, I will not take more than 5-10 minutes. My lord, in fact, they also realized because, my lord, 2006.
What about the other appeals?
My lord, other appeals is, my lord, the same issue. One is on the interest, 96-97, base tax, whether exigibility of tax, and then interest, which follows, my lord, and the other is 98-99, my lord, I had filed a suo moto appeal. So there was no assessment. So there is no interest there, but the same issue is the same. So there, my lord, in both the cases, our stand is that in view of that amendment being retrospective, in view of this latest judgment of the Supreme Court, it can't affect the liability of the deductor. Therefore, my lord, as far as we are concerned, the review has to be rejected. That is one. As far as the penalty is concerned, my lord, I have already made my submission. Your lordship can look at the order. There is only one ground in there, and that also factually incorrect.
But that penalty would not be connected.
No, it will not be connected because there all your lordship will have to see whether, even assuming penalty, I argue, assuming there is a liability, all your lordship will have to see whether there was a reasonable cause or not, which ITAT has discussed in detail all the facts, all the opinion, etc., dates, and come to a conclusion that there was a reasonable. And, my lord, subsequent events are also important. My lord, what has happened is the Real filed for assessment in Bombay. And there, my lord, they claimed that there is nothing exigible to tax. ITAT on March 2016 has held in their favor, saying that not even 1 rupee is exigible to tax. That matter is pending in the High Court. A department has gone to the High Court. Matter is pending there. But this subsequent event will also show that even till date, there is no clarity whether there is exigibility of tax or not. Bombay says, my lord, ITAT, there is no exigibility. My lord, today, the Karnataka High Court judgment is that only portion is accessible to tax. So even on that basis, my lord, where is the question of any, there was a bona fide belief that that is still in dispute after, my lord, 20 years. That is still going on.
What do you say, sir?
Your
Mr.
Lordship,
Tanmay?
there are two types of cases, my lord. One is regarding tax, another is penalty, my lord. As far as tax cases are concerned, my lord, there are after the disposal of the 8080 order, my lord, there are two amendments, my lord, which are coming to force, my lord.
No, we'll do one thing. We'll have it together only, Mr. Dutt. Now, how long it would take? We'll just see. We have passed over. We'll just pass over the matter.
My lord, on the penalty, I will not take more than 10,
No,
15.
but we'll hear it together, Mr.
Very well.
Why not in piecemeal? So we'll come back. We'll just pass over. We'll see.
Very,
Okay.
very.
Yes. Just call the other matters also. Just run through the other.
40, 46, 47 urgent, 48, Sri Raghavendra,
My lords, I am appearing in these matters. And
48,
My lords.
my lords, I am appearing in these matters.
Is it part of matter? No?
It's a part heard, my lords.
Part heard.
We have
Yes.
completed our arguments.
Respondent.
It's a matter where my lords, railways has to reimburse the service tax. Whether it's reimbursable or not was heard 2 weeks back by your lordships. Sir. Lordships had asked one question of us. That is,
We recollect, Mr. Raghuram.
my lords, deeply obliged.
Who appears for the respondents?
Sri Abhinay,
For the railways, my lords.
Just to say password. Next.
Deeply obliged.
49, Sri Sanmati,
Your Lordship, 14, it may kindly be adjourned for 2 weeks, my lord. It may kindly be adjourned for 2 weeks, my lord.
Just say that at the request of Mr. Sanmati, re-notify. We'll just say submissions also.
Please, my lord.
Submissions also, just say. These are connected matters, no?
Connected matter.
50,
20th January, sir, 50,
My lord.
Respondent.
Short matter, my lords, we're ready, but I understand my lords have passed over quite.
it may not be possible today.
I'll leave it to my lords. We won't take long, my lords.
Just
Any
say
date
re-notify.
convenient to
We'll
my
just
lords.
have it re-notify.
Please.
6125,
Obliged.
51, 52 urgent.
You come back after lunch.
Sir, sitting 245, sir. Sir, from portal 2, sitting at 245, sir. Advocates online.
Okay, ma'am. Thank you.
245, sitting 245, sir.
Thank you, ma'am.
Petition ಬಂದಿಲ್ಲ. Mostly, I think those fellows are taking adjournment. ಅದಕ್ಕೆ we have to make some submission ಅಷ್ಟೇ. ಬಂದೇ ಇಲ್ಲ ಅವನು ಕೋರ್ಟ್ಗೆ. ರಾಘವೇಂದ್ರ has told him ಪಾಸ್ವರ್ಡ್ ಆಗಿದೆ. ಓ ಪಾಸ್ವರ್ಡ್ ಇದೆ ಅಲ್ಲಿ ಕಮ್ಮಿ. I need some. Yes, madam, what is this? Oh, ಹಾ ಆಗಿದೆ ಅದು.
Similar to Alva's what the
Was not at all ಇದೆಲ್ಲ ಆಡ.
Sorry, we are late today.
Yes.
What did you say? The counsel for the respondent seeks further time to take instructions at his request be noted. Show the last order, ma'am. Okay.
212.
Yes.
Obliged.
No passovers.
First door matter, serial number 6. Serial number 6.
Yes.
My lord,
What do you say?
my lord, this is with regard to my lord, grant of an interest on refund as directed by the lender. I just, my lord, take your lordships to. This emerges from the, my lord, the orders passed by the Honorable High Court of Mumbai.
That's right.
Now, your lordships may peruse the, my lord, the order passed by the, my lord, the Honorable High Court of Mumbai for a moment. May I just, my lord, the direction to whom? My lords, may 111 page number, paragraph 30.
The direction to whom?
Respondent, my lord, paragraph 30 of, my lord, order passed by the Honorable High Court of Mumbai. Accordingly, we direct. Lordships are with me, my lord.
Who were respondents 3 and 4?
3 and 4 are, my lord, Maharashtra, my lord, GST authorities. I was respondent number 5. I was a formal party.
Where is this plea taken before the learned single judge?
My lord,
See, this is a new plea.
no,
At least to my,
quoted from the records of the, my lord, court.
where is the plea taken? See, you should advance the plea, no? Maharashtra now, see those proceedings, Bombay proceedings, now they have come back to Bangalore.
In
So
Bangalore,
Maharashtra was not there.
no, lordships make a list, my lord. How this thing happens.
You are right. Where is Maharashtra a party?
Maharashtra, there is no party.
So then
Before
you
the
should
learned
have said,
single judge.
you should have said so.
My lord, I agree, my lord, that aspect, my lord, not pleaded in the, my lord, the statement of objections or.
Who will
where-
plead?
The revenue.
Obviously, they were to plead.
The revenue should have pleaded.
Obviously, that's the point.
Yes.
Now, in the absence of it, what follows? See that otherwise, looking at it, prima facie, it's a proper order. Bombay High Court says so. With interest. It says with interest.
No, my lord.
And you don't file it, you don't pay interest, you follow the procedure under that provision. That for refund, you have to file an application, then they will consider it 60 days thereafter. How can that be when there is a court order?
Yes, make one submission. This refund order, this order, my lord, the Honorable High Court of Mumbai has exercised the equity jurisdiction. My lord,
We will not go beyond Bombay High Court.
yes, I don't want,
We
my
will
lord, my lords to go beyond, my lord. I also don't want to traverse, my lord.
Okay, so if that be so, in terms of Bombay order, from which date the interest is accrued, interest has accrued?
My lord, my lord, they said that from the date of receipt of the copy of 4 weeks from the date of the receipt of the copy of this order.
So order dated,
My lord, this order dated. My lord, September 15th September
2020.
2020.
so let's assume October 15, 2020. That's it.
October 2000, that period expires.
Now, we don't know, you have not taken this plea before the learned single judge. People shall refund the amount. Covered by the 8 in kind.
My lord, according, my this thing, my lord. A statement of objection filed by the revenue may not be a part of this. It is that. Well, the statement of objection is at page number 192 filed by the revenue for the learned single judge.
And why did they file this petition here? Why did you file it in Bangalore?
My lord, this is how it operates is this. Jurisdictional adjudicating authority is in Bangalore. Now, my lord, there is in GST, my lord, there is a cash ledger, credit ledger, electronic credit ledgers, electronic cash ledger. They are maintained by the jurisdictional assessing officer. Whatever the amount he deposited by virtue of the, my lord, this proceedings before the Maharashtra state GST authorities,
Just one
they
minute,
stand
Mr.
credited to his account. My lord,
You don't take now directions to the Maharashtra 3 and 4? We will hear that this requires consideration.
Well, I think, my lord, some observation was made by the earlier bench and directing them to make the Maharashtra GST party.
You should make. We are not understanding, it's a question of liability. If any liability need to be discharged, who would do it, whether Maharashtra or they? You
No, my
should
lord,
make.
we have, my lord, ready, we have granted refund because whatever he had deposited by virtue of the proceedings before the Maharashtra authorities were deposited in the cash ledger of the.
Transferred here.
As an adjudicating authority, jurisdictional adjudicating authority, I have done it. But this is a penal interest for having excessively, my lord, collected this.
Those illegal.
That equity has to be done by the, my lord, the person who has.
Those bank guarantees were illegally.
Yes, my lord, illegally encashing the bank guarantee. That action, that has to be, my lord.
Just say that at the request of counsel for the respondent, when do you want? See, otherwise you should have gone back to Bombay and say that, look here, 3 and 4, did not discharge. How can the liability come on them? We'll see. Just give a date.
25/11. Serial number 13.
I need over one list of dates in morning, list of dates, morning award.
Yes.
It's only, principal contention is, when they had efficacious alternate remedy, they could not have gone before the writ court, challenging the tribunal order. They should have filed a 260 appeal challenging the tribunal order. This is my first contention. I filed a list of dates. I'll just take your lordships through that. This is for assessment year 6, 7 and 7, 8. The assessment order was passed on 31st December 2009. Later on, they challenged that before the Commissioner of Appeals. Commissioner Appeals on 38th August 2010, dismissed, telling that admitted tax was not paid. They challenged before the tribunal, tribunal also dismissed that. They filed a miscellaneous order against the tribunal, my lords, tribunal recalled its earlier order. Again, my lords, after recall in 2013, 22nd February 2013, my lords, tribunal again dismisses, my lords, admitted tax is not paid. My lords, after lapse of 10 years, my lords, they filed a writ petition against challenging the tribunal order. In 2020.
Let's see their list of dates. Let's see their list of dates. Come to the petition.
The writ petition.
That's right.
Please.
Come to the writ petition.
Please.
Or you come to your list of dates only in this appeal.
Please.
February search. This is after the assessment.
Please, my lords. After the assessment, my lords, they challenged that order before the Commissioner Appeals. Commissioner Appeals, my lords, dismissed their appeal, my lords, self-assessment tax, it's admitted tax not paid. So the Commissioner said, my lords, it's not maintainable under section 249. Lords, learned single judge relies on a decision which is in my favor and grants relief to them, my lords. The decision squarely applies, my lords, it supports my case.
Now the assessment years are how many?
No, it's 2 assessment years, my lords.
2004, 6?
My lords, 6, 7 and 7, 8. 6, 7, assessment year 6, 7 and 7, 8, my lords.
What happened to 4 and 5, 5 and
Lords,
6?
Lords, I think those matters.
That has attained finality. Your
Lords.
appeal was dismissed.
Lords, I think that.
Appeal was restored. Appeal on merits not allowed in my favor. The revenue came to this high court. Court dismissed the.
That's right. Okay, now we are for the later period.
6, 7 and 7, 8. my lords.
Now dispose of application, respond. Where is the impugned order?
Lords, single judge's order is, my lords, at page 11. It's the impugned order before the learned single judge, my lords, it's at page 40, annexure A. Page 40, annexure A, my lords, before the learned single judge impugned order.
No. See, tell us one thing, how can the learner single judge, such an old matter revived? Yes.
Before, my lords, I'll place the judgment which learned single judge has relied on.
This Komalakshi.
Please, that judgment is. Because the judgment that it's squarely is applicable to my, it's in my support. Lords, after relying that judgment, relief is being granted in their favor. My lords, in that case, my lords, after the tribunal rejected that order,
Now, let's hear him. Yes. Just switch on that mic.
Sorry, my lord. The C company was run by one Mahadev and his children were abroad studying. He died on 18/12/2009. And the affairs were left to his children. There were a lot of issues on liabilities in several group companies, not only this particular company. Now, as far as the facts of this case are concerned, my lord, the appeal was filed by the assessee for the assessment year.
What was the assessment year?
For the assessment year, 6, 7,
2006 and 7
and 7 and 8.
and 7 and 8.
And also there is appeals were there for assessment year 4, 5 and 5, 6.
That's over now.
It is over, but then that has an implication on this decision-making process because, my lord, there also we had not paid admitted tax and subsequently we paid admitted tax. Appeal was entertained and appeal was allowed in my favor. The department went to tribunal. Tribunal gave me relief. Identical issue. There's no change in the merits of the matter.
Let's take that.
Lordship, that is one thing. I stated it. In fact, I put in my written synopsis also. I filed my
Just give that.
file
Yes.
with all the case laws and. What happened, my lord, was the appeals were filed before the commissioner who dismissed it and the matter was restored back to the tribunal. Tribunal is purported to have passed the order dated 22/3/13, which is at page number 40 on 22/2/2013. Annexure A, page 40. But we had not received the copy of that order at all. And the department also right from 2013 till 2022 did not raise the demand to make the payment. It is very, very important that none of us were aware that the matter has been disposed of. Then
By whose order dismissed?
The tribunal order dismissing on account of non-payment of tax. The issue is not decided on merits of the matter. I did not pay the admitted tax. The tribunal disposed of the matter by saying the appeal is not maintainable.
But that's your appeal.
My appeal.
So,
My
so
appeal.
you must be privy to it.
We were not privy to it. We were not aware.
It's your outlook.
No, my lord, I'll come to that. We were not even put to notice on that. Order has been passed. I'll come
Tell
to-
one thing, who filed an appeal?
I filed an
You have to
appeal.
pursue the appeal.
We have pursued the appeal, but then the notice and the thing didn't come to us.
I notice, Mr. Shankar, why notice?
But in tribunal, there are 7,000 appeals pending, my lord.
Forget it. This court issue notice whenever you file an appeal.
Your lordship.
Don't know the procedure about IT-80, but that's the procedure.
No, my lord, IT-80 procedure is after issuing of after the appeal is filed, a notice will be issued, my lord.
Notice is issued.
Yes, my lord. Standard practice. No, be that may, my lord. It is the
Then
fact,
it's fine.
it's the fact of the matter. Now, let me explain the chronology in 5 minutes. Your lordship will appreciate the background. Then what I did was the department also did not demand 1 rupee money from me for these 2 assessment years from 2013 till 2022. In 2022, that one of the officers told me that these appeals have been disposed of. So I wrote a letter to the tribunal saying, which is at annexure P, page 325, stating that I have not received any order, please give it to me. After 2-3 correspondences, they delivered that order to me on 29th of April 22, and I filed the writ petition within less than 2 months from that date. So it is not that I was aware of it. And the biggest advantage, my lord, is positive point is the department did not issue a single notice that I have not paid the taxes for 10 years. If the department was aware of it, they would have recovered that money from me. I would have probably been aware of it at that point of time. So ultimately the tribunal gave me an order and we filed a writ. Basically because, my lord, such a long gap. And the tribunal said, I asked them the proof of serving the acknowledgement. They said, it is a long back matter. We have weeded it out and we do not have. Those matters are there in the record. I can read it out if required, but your lordship can take it as a matter of fact. The tribunal wrote a letter stating that we are not able to give you that. So in this background, we legally advised that the right remedy would be to file a writ petition, basically because of three reasons. Reason number one, long gap, tribunal does not have record. Department did not issue a single notice to me in this 10 years saying that I have to pay the taxes. Third, my lord, is that the issue is covered in my favor for the earlier 2 years and also by the two division bench.
But where is the reasoning given by the learned single judge?
My lord, the reasoning given by the judge, your lordship will notice is that how the matter went, my lord, your lordship will notice.
You see the order.
Yes, my lord. Basically, it was an order in which both sides were heard. It is not that it was a one-sided order. The single judge says, my lord, is like this.
Where does all these contentions raised and dealt with? It's a very issue is, you would agree, Mr. Shankar, it was highly belated. You may have a justifiable reasons. For these reasons, surely the delay cannot be attributed to you. You can say so.
Yes, my lord.
Surely. But that should be reflected,
but
saying that these are the reasoning insofar as the delay is concerned, and hence the court is of the view that it need to go back and decide on that.
Lordship.
That's all get around.
But what actually happened in reality at the time, because I only appeared, my friend only appeared, was the matter was heard and the single judge took a decision and these facts are there before it is not there in the writ petition.
No, we were saying how we will know that these are the considerations, these were the relevant.
I'm sure my friend is there, my lord.
That's right.
My friend is there, you are the party to it. And the point, my lord, is fortunately for us, both of us only appeared. The issue is, my lord, that here is a case that admitted tax, there are two main reasons. That it is paid very belatedly. If it is paid very belatedly, a division bench of our High Court has held, paid belatedly also, the matter has to go on merits, and I have listed out which I'll take your lordship through. Second is, my lord, with reference to this Komalakshi. The Komalakshi judgment is basically, they said it is liable to be rejected, but if they are paying the taxes, it should be entertained. So it is not the case that Komalakshi was against us. Komalakshi, lordship may see at page 332, the decision is in our favor. How the single judge has written, because ultimately your lordship are aware.
That is one thing. Having filed the appeal, you did not pursue your appeal.
We pursue.
You are waiting for the notice to come from ITAT.
That is how in practice it happens in tribunal. With all my experience and humility at my command, handled more than several thousands in the tribunal.
Years. How many years was the gap?
No, my lord, what happens is sometime in some period, what happens, the gap can be as long as 5 years. Sometime the gap can be.
After filing.
After filing. Now it is coming. After filing, after 5 years.
It comes for preliminary hearing after 5 years.
Yes, my lord. There's no preliminary hearing there. It is basically one final hearing only. It will happen. At the time adjournments are taken. The issue, my lord, in tribunal procedure is basically the moment an appeal is filed. Now, what is happening is, in fact, after 2000 COVID-22 onwards, when you file, they give one first date. That is not a date that effective. There is no preliminary and admission and all. Everything stands admitted once of appeal is filed. That is the process in tribunal. So a date is given to us on the day on which you filed an appeal. That is procedure started in 22. Earlier, I remember to have received notices for 82, 83, and 96 also. It happens basically because at that point of time, there were more than 10 or 12,000 appeals pending in the tribunal. So they are not, moment the new appeal comes, they will simply bunch it and put it. I'm not getting into how the procedure is. All I'm saying, my lord, is I have not received the order. I am not even told by the revenue even once in 10 years. If they have received the order, they would have told me to recover the money. And I wrote to the tribunal. Tribunal said, I do not have records, but I got a copy of the order and they gave me the copy of the order. I asked them the proof of acknowledgement. They said, we do not have because it's a long overdue.
When did they give you the order?
They informed us March 2022. Within 1 week, we filed a letter to the tribunal.
Is it a fact?
It's that I have to verify, my lords. That
no, if the procedure is this ITAT procedure.
My lords, that, my lords, after filing, my lords, ITAT will issue a letter, my lords.
Then obviously, how would they know?
My lords, I am altogether on a dip. My lords, the impugned order before the learned single judge is an appealable order before your lordships under 260A. My lords, whether the assessee should be allowed to do forum shopping, my lords, when there is an appeal provision, my lords, that is my principal contention, my lords. When there is an appeal.
226 jurisdiction. Tell us one thing. Okay, you are very well. We'll look into that. But even assuming let's relegate them to the ITAT, will this be the conclusion arrived at by the learned single judge will make any difference?
My lords, they've paid admitted tax after 10 years, my lords.
Obviously, no,
After-
this is before filing the appeal,
Before filing the-
After
before filing the appeal,
Before filing the
after
writ petition.
dismissal, after
before
dismissal.
filing the writ petition.
Yes, my lord.
When
I
you
enclosed
got
the
that
chal-
order.
Yeah, on the, I have enclosed the challans also.
See, then you should not fault the litigant saying that the litigant was sleeping over.
Lords, it sets a wrong precedent, my lords. That is my lords. Every assessee, my lords, will challenge the tribunal order before the single
If
judge.
in any
Lords,
case, if the ITAT doesn't issue notice, the litigant would be under the belief that I'll get a notice for appearance.
my lords,
And
that
such
they
a
can-
case comes, we will follow the same thing what has been done
my
by the
lords,
learned
they
state.
can always take up that contention before a lordships under 260. My lords, your lordships can call the records from the tribunal and verify.
What?
My lord, whether the notice was issued to the assessee at that particular, when the appeal was filed before the tribunal, whether the notice was issued by the tribunal, your lordships can always call, my lords,
We
when
can
the-
call, he
my
said
lords,
that
this say-
the record doesn't exist there.
Yes.
my lords,
Similarly,
my lords, that is their statement, your lordships can still call it for records, my lords.
Okay, we can call for the
Lords, that-
ITAT record. When
Please,
did
my
they
lords,
issue notice?
my lords, the impugned order before the learned single judge is ITAT order.
But as a procedure, tell us you, or you agree with Mr. Shankar?
Please, my lords, what happens is, my lords, after the appeal is filed, sometime notice will be issued, my lords, fixing the date of hearing to the assessee.
How did you appear?
My lords, we are department
there,
secretaries,
you
we are always.
department
there-
secretary is al-
every day the list, full list comes to them, my lord.
Let's see
Yes, my
that,
lord.
let's see that order by which they rejected their appeal.
Annexure A, page 40, my lords.
It's a none for the SSE.
Please, my lord, it says none for us. On the first page itself, my lord.
Just imagine an ITAT which the appeal filed in 2010, taken up for hearing when
2013, they have done it.
Say, it, my lords,
3
it
years,
was-
after 3 years.
It happens. Now it is actually four.
That's after filing this.
Your lordship may also see page 329.
See, this being.
My lords, it was dismissed earlier, my lords, of non-appearance. Again, they filed an MP. It was recalled. After recall, again, they have not appeared.
Before this order,
Please,
Yes,
my
ma'am.
lords, that I have mentioned in my list of dates. Your lordships may kindly refer to my list of dates.
Your lordship is a please.
the order at page 40.
Please, my lords.
Now tell
before
us,
that-
Mr. Shankar, did you appear in the appeal before this order was passed on in 2013, 22nd February 2013?
No, no, my lord. We didn't appear.
My lords, they have.
What is the date of appearance
My lordship may say 329. I have not appeared before the tribunal at all. my
at all?
My lords, but they, against the dismissal, they filed a miscellaneous appeal.
Yes, I have filed.
They filed a
aware of it, I
miscellaneous
filed.
petition. My lords, it was recalled. The original order was recalled.
Then,
And
Mr.
it-
Shankar, you are pursuing that litigation.
Yes, my lord, your lordship, that's why I
Taking a
said
chance.
329 may be seen, my lord. I said, I have not kept anything away from anybody. We were definitely pursuing. But unfortunately, that order, that day we did not appear. We are not aware of the order. Ultimately, my lord, the order passed must be served on me. It has not been served on me is my case. All I am pleading, my lord, had I appeared and the same order has been passed by the tribunal, because at that day I had not paid admitted tax. The tribunal could not have passed any other order on that date. Because on the day of 2013, I had not paid admitted tax. Whether I appear or not appear, that fate accompli of that order is that and that alone. And your lordship may also see for a moment the decision of this court in SS projects.
That's on merits, my lords. I'm not even
No, no,
contesting on merits.
Where is this order of recall?
My lords, they've not produced it. I,
What does it say?
They produced, page 179.
it's a 179 annexure F.
179 of your documents?
My lords, it's writ appeal, my lords.
Writ appeal.
Annexure H. my lord. Para 2, my lords. Page 180, my lords.
Was it a date given matter?
It would have been, in my opinion, I don't have the copy of
That's
the
the
order.
very fact they
but-
filed adjournment letter, my lords, they were aware of this proceeding.
No, why we say is this,
My lords, this-
even today, even date when the case is posted for hearing, none appear for the.
Please, my
SSE.
lords,
Yes, my lord. Might
Lords,
have been given date.
they
I'm
cannot.
not-
really-
I mean, as a practice, I do not know in the facts of this case, I don't have copy, but I know as a practice from the tribunal side, as officer of the court. Normally, MPs, when they are recalled, the date is fixed. As a-
So date is fixed?
That is a.
So you are aware of this date of 2013?
I am not, my submission to your lordship is not that I'm not aware of the date. My submission to your lordship is that irrespective whether I have appeared or not, The order that would have been passed is that only it has not been communicated me for me to take up with your lordship.
We will not just say this. You were required to appear in the proceedings. You did not appear, yes or no?
That, to that extent, from record shows you have not appeared.
Then did you pursue the appeal even thereafter with the
My lord,
ITAT?
by then they pursued the appeal in the sense, then by the time they have passed the order, we were expecting another notice to come. That notice didn't come.
No, then we can't take that.
That is the position in law, my lord.
That we can't take.
My lord, the whole thing is how your lordship may notice, see the colossal damage that can happen to an assessee that he has not paid the admitted tax. Had I appeared on that day,
So that's a consequence of your appearance.
I have not.
But here we are considering
our
the consequence of your non-appearance.
Our grievance, my lord, is that the order has not been served on me. It's not the question of whether I appeared or not or pursued. The order has not been served on me. If that order, and not only on me, even on the revenue to my best of my knowledge.
Mr. Shankar, you have such a vast experience at the bar.
Yes, my lord.
Now, will the litigant will expect, see, it's like this, in a normal course.
Normal course. It'll get.
Date is there, I appear. I don't appear as a counsel. Surely I will maybe for XYZ reasons, I will go to the court back, see what happened in that matter.
That is.
And then pursue the matter thereafter.
Your lordship, that is the normal course which a person does. But your lordship may understand this group of case an extraordinary case basically because your lordship have to understand that the problem is this child which came from abroad had more than 200 litigations. He did not know what to do. So based on that, the position is, my lord, every day is firefighting, and your lordship may see page number 203. In fact, they have, in the case of a connected matter, how the department has taken note of all these things and given us relief of waiver of interest. 110, my lord.
See, today he is more on, the counsel is more on the delay latches.
Not delay, my lord. My point is I have not been served with the order. Once I am not served with the order, there is no presumption in law that it has been served to me.
We can't take that, Mr. Shankar.
That is the legal position. Please, your lordship may consider taking into account for 3 facts. One is I have not received the order, point number 1. Point number 2, the moment I got the order, the most important thing is, my lord, department has not even asked me once from 2012 when the order is dismissed till today, the demand is required to be.
You can't take the benefit of that.
I'm not taking the benefit of doubt, my lord. My lord, when they have been issuing notice after notices, everybody was under the presumption that the order has not happened. Otherwise, they have issued notice. Your lordship for a moment may take to page 110. It is something that happened in a connected matter of the same group in 31/1/2018, where we have explained all our difficulties and told them that your interest has to be waived, and the department was pleased to waive the interest. Page 119 may be seen, para 5 and 6. I have demonstrated everything in my writ petition by putting all the papers to say that I was in difficulty. All my group companies were in appeal. I did not have money to pay. All my properties were attached. I could not have paid. And then one by one, as and when money was coming, we were paying. And all the appeals at which was restored have been allowed in my favor.
This is the reason for you to not to pursue.
No, my lord. It's not.
What?
No, my lord.
See, then how can that be equity come in your favor?
Your equity, my lord. Basically, your lordship may see page 110. If I had no equity, why will they waive my interest, my lord? The lordship may notice that the entire interest has been waived.
Yes.
They have waived the interest. My submission, my lord, is this. And on the merits of the matter, your lordship may also take one decision in terms of payment of time, which I have placed at page number. Document number 13, 106 may be seen once first, my lord.
Page
Of my compilation, my lord. Today's compilation. 106. That's a division bench judgment of this court. At page 108. At para 4, second part, before para 5. 5 lines before para 5, my lord. Therefore, the appeal dismissed under clause A of subsection 4 of 249 for non-payment of admitted tax due on the income returned by the assessee cannot be found fault with. However, if after such dismissal, the assessee pays the admitted tax and reopen the appellate authority recall the order dismissing the appeal in limine and to consider the appeal on merits under the aforesaid provisions or any other provision of the Act, there is no prohibition or legal impediment for the appellate authority to recall its earlier order and entertain the appeal and decide the same on merits. And ultimately, they have sent it back. Now, your lordship may also see page 99 Another division bench of this court, my lord.
But tell us one thing.
Please.
If he was to pay the admitted tax and then approach the appellate court, ITAT,
My lords, then they would have considered on merits, my lords.
and then it would
My
have.
lords,
That is precisely
after-
what the single judge has
my
done,
lords,
my lord. And he has not given me
my
relief.
lords, my submission is, my lords, after the tribunal dismissing for the first time, they filed a miscellaneous petition and it was recalled. Subsequently, again, it was dismissed, my lords. After delay of 10 years, then they have paid the admitted tax.
No, but in any case, under 268, what is the limitation?
My lords,
60 days?
120 days from the date of
120 days
receipt of
from
the
the
order.
date of receipt of the order.
120 days of receipt of the
The
order.
order.
It is the order for us we have filed within less than 60 days. Their
Precisely, my
contention
lords.
is I have
My
not come to this
contention-
court, I have gone to.
They should have come before your lordships under 268. Else they should not be allowed to do forum shopping is what. But it's they cannot pick and choose, my lords. That's my principal condition. When there is a
In
statute.
all these cases where a direction has been given, pay the admitted tax and then
Please, my lords,
appeal be entertained.
please, my lords, my lords, your lordships may kindly refer to Komal
This is-
Nasi, my lords. In this order
No.
itself, my lords, this honorable court, my lords, has said they have to pay. It's a mandatory condition, my lords. And in fact, it's a concession order in the last para 12, after dismissing, at this stage, your lordships had A. Shankar, counsel for the assessee, would say that he would advise his client to make good the admitted tax in terms of the return filed by them for the purpose of consideration of appeal, for which he wants some breathing time for making such payments. In normal course, we would not have considered such request from the assessee. However, taking into consideration of the facts and of the case, we deem it proper to accept the submission of the learned counsel of the assessee. We therefore give him 4 weeks time to make over admitted amount before the authorities. My lords, even in this case, my lords, after rejection by the tribunal, they filed an appeal under 260A. They've not approached a single judge, my lords, against the rejection of the tribunal rejecting their appeal. My lords, they filed an appeal under 260A and this order is passed under 260A. Not under the writ jurisdiction.
106 may be seen. And your lordship may say 103 may not be, a compilation. Another division bench of this court. Latest, my lord, recent. Starts at 99 and the relevant observations are at para 5, 103. There is the same contention what my friend is taking. Learned counsel for so-and-so would not dispute the legal position because that we relied upon the dictionary of Satish Singh, which I took your lordship, which is at page number 106 onwards.
This order also is.
Learned,
60A.
I have no quarrel on that, my lord. Learned counsel A.I. Sanmati would not dispute the legal position, but would submit that since the tax amount due from the appellant was for the assessment year 7-8, and that the appellant had deposited admitted tax in installment till 2024. So that is also a classic case where the person did not have money and huge, my lord, how the 249 works is, if I don't pay admitted tax, whatever addition they have made, we have to pay tax on it, whether legal or illegal. So in view of that, my lord, courts have always been liberal in respect of once the admitted tax are paid. Here, admittedly, we have paid it. And the court, remand, all we are saying is hear me on merits at the down the line. Beyond that, we are not saying anything. Our case is one of case where we want the.
It's admitted tax is not we, my lords. It's they themselves are admitting.
There's
that
no
is
quarrel, my
admitted
lord.
tax,
There's no
my
money.
lords.
There can be several reasons why a person will not be able to tax. My friend has not been on the business side. He has been on the revenue side. Para 8 also may be seen, my lord.
See, this is a petition which was filed in 2014, immediately after that appeal.
No quarrel. Here also we filed the writ petition within 60 days, my lord. That is our case. It is not a case. There is no record or anything with the department. If the department has said it has been come to us in 2013 or 14 itself, we would have filed an application for condonation. There is no record available. It has been served on us. Not even one whisper which they have collected demand from so many of our group companies. Same officer. One officer who is handling the entire group. He doesn't even tell. There is a demand in this case. And for 2 years, we did not pay. We paid the admitted tax, which your lordship will get it at page number. For the current year, for the earlier period, for 4, 5 and 5, 6 also, CIT, ITAT, High Court order are there at page number 148, 203 and 225 per petition. Same issue is involved the same, where in fact the revenue filed an appeal against the relief given by the ITAT after my paying the admitted tax. This court dismissed the appeal. The issue is the same. It continues whether I'm entitled to a particular relief or not. In this background, if your lordship, we legally advise that equity court is more appropriate.
But tell us one thing, why should on an issue which stood settled in favor of revenue be?
My lords, the
Same issue,
my
yes,
lords,
my lord.
more on the procedure, my lords, a 13 years
Technical.
delay, lords, 13 years delay. They've not explained, my lords, for not paying.
We are not paying, we didn't have money, my lord.
Even after dismissal by the tribunal, my lords, they've taken 13 years. And my lords.
We have paid,
more on-
we have
my
paid
lords,
within 2 months from the time we got the order, my lord. And then only we came to this court. We were legally clearly advised that unless you pay the admitted tax, the question of proceeding doesn't advise with advice given.
Which year stands settled in your favor?
Your lordship will get it to page 225, my lord, of the petition. For the earlier 2 years, 4, 5 and 5, 6. Same issue. It's continuing the issue for the next year. $225 million, sorry. High Court order is at 225. And for this year, the earlier order is relied upon to pass the assessment order. Issue is, and anyhow, I have not this.
Which year?
For the impugned assessment years before your lordship being
That's right,
2006,
that's right.
7 and 7, 8. The issue that it's a question of whether I'm entitled to a benefit or not. It percolates year after year. The first year was 4, 5. It's the same issue involved. It is not the case that we argued with the single judge that we should be given relief based upon these orders. All we requested the single judge, which my friend also was there, was to put it back to me on square one, let them decide if I'm eligible or not. We have put all papers in the writ petition as comprehensively as possible. $141 may be seen, my lord, page.
Reconsideration is on merits?
On merits. That's all,
PN
because admitted tax we have paid now. Now they have to dispose it of on merits. They've gone back to CIT appeals. The demand continues before the assing.
Now this remand is to whom?
To the
CIT
Commissioner
appeals.
appeals.
CIT appeals.
Because if it goes to before the AO, the remand will go. And we did not even ask for it, my lord. In all fairness to the revenue, we said the assing officer has passed the order. Normally, when the remand goes to the assing officer, the demand goes, fresh demand has to be made. We said you send it back to CIT appeals, from there let it start. That is where the problem started for us.
Okay, we will consider everything. Thank you. Reserve.
My lords, learned single judge, my lords, whether based on their statement, my lords, admitted tax has been paid, learned single judge is allowed. My lords, we have not, I'm not sure whether they've paid interest on the admitted tax, my lords, because there was a default of about 9 years. My lords, whether the interest was paid, it was never verified, my
The
lord.
lordship may take to the.
You should verify.
Lords,
No, my lord, my friend has raised this issue. Your lordship may take to the compilation. First of all, 249 does not contemplate payment of interest. Your lordship may, same issue was raised and how our High Court has already dealt with the matter. Page 99 may be seen.
What does it say?
I'll read it. I'll read it. Page 90.
Chalo.
Yes.
Page
104.
99.
104, my lord. Of my compilation.
Which para?
I'll read, my lord. Para number 8. Para number 5. Para number 5. The appellant has deposited the admitted tax in installment till 2024. The respondent revenue has to be compensated by way of interest. That was the case which they placed before this division bench. The reply given is, to the above submission, learned senior counsel so-and-so would submit that in case the appellant fails in appeal before the appellate authority, the appellant is bound to pay interest from the date of the order till it is deposited. The interest is basically nothing to do. See, for paying admitted tax in terms of section 249, we are supposed to pay the tax portion. That is what we have to pay, my lord. And the challans are there at page number for having paid. Annexure V, V1, V2, my lord. And we have, in the synopsis, we have put the information.
The file is synopsis. We'll look into it.
Public.
Thank you.
Public.
Reserve. The next matter.
Serial number 18.
My lords, I'm seeking some time to file the synopsis, my lords. Mr. Sushal Tiwari is not available.
Just say submissions be filed by the parties before the next date of hearing, re-notify.
6/1/25,
Obliged, my lords.
serial number 25.
My lords, I appear for the appellants. My colleague, who's the advocate on record, is unable to join the BC, my lords. He's having some technical issues. So small accommodation will be made. He'll be present before the court on the next day physically, my sir.
At the request of counsel for the appellant,
Yes, my lord.
re-notify.
Please.
25/11.
Much obliged.
Okay, you are there. This is the same pattern, no?
Please, pattern.
Yeah, we'll have it. He has some difficulty.
Yes, my lord. Part heard matters.
Give a short date.
25 minutes.
Oh, this Monday. When have you given? November.
Obliged, my lord.
25/11. Serial number 39.
Lords, 39, I beg to appear, lords.
How long it would take?
My lords, I'll take about 15 minutes, 1-5.
We'll just file your submissions. I think that would be better.
My lords, we've already filed a synopsis.
Uh,
My lords, may set it down for hearing. My lords, I have no difficulty.
other
We
synopsis.
was filed on 1st of December 2023.
Record.
Lord, I would like to file my submissions. I'll also file my submissions.
Let's see, their submissions are on record. Just check up. He's showing 1st of December.
For 1st December 2023.
Yeah, fine, you know. Just show that it is new. Okay. Okay. Just show us the order sheets. Okay. So let's see. Okay. Just submissions be filed by the counsel for the respondents. 4 weeks. Next.
My lords, the interim order may be continued, my lords.
Interim order, if any, to continue.
And my lords, may I request if my lords can accommodate me on 25th November, my lords, I'll come. We can, because these writ appeals have been pending.
25th, see? Just show us, man. Not possible. We can give you only a Monday.
Well, it's good then. 9th, sorry, was 16th December.
Just see 16th. Man. We can have it. Huh? Yeah, we can have it on that.
I'm so grateful. I'm so grateful.
December. 43. Serial number 40.
This is
the learned single judge, where, my lord, the directed the department not to, my lord, take any action against the respondent hearing. Agreed by that observation, I am before my lord, sir. This is where, my lord, they are all contractors, undertaken a contract from a government or a government agencies. My lord, these contracts, civil contracts were, for our civil work, were entered into prior to the GST coming into force. Now, my lord, though the contracts were entered and rates were finalized before this GST came into force, and the work was completed, my lord, and the amount was received by these contractors in the after the, my lord, the GST came into force. Now the demands were made under the new GST regime. Now in that event, my lord, they said that the rates were finalized without taking into consideration this GST element in the contracts. Hence, the contractors were put to loss. We can't, my lord, under these circumstances, we cannot, my lord, legally we cannot fulfill the, my lord, or the demands as raised by this thing. My lord, they approached this honorable court. Now the learned single judge, my lord, directed the contractor as well as the contractees to sit and, my lord, finalize the, my lord, rework the, my lord, the terms of contract. And no action should be initiated for non-filing of a return or non-payment of a GST against the, my lord, the contractors, my lord. That is the.
Yes.
So far, my lord, lordships, may I just draw my lord's attention to, my lord, page number 166.
Where is the impugned order, Mr.?
My lords, this is impugned order is at operative portion is at 166, my lords. It starts from page number 18, but the cost title itself is, my lord.
See, it appears my
Sir.
In my this thing, that particular pages are missing.
Lordships, may I just internal page 149, lordships. There may be some, my lord, while.
You file your submission, Mr. This is a big judgment.
No, my lord, the judgment is not big. Cost title is big, my lord, because there are several writ petitions, my lord, filed by the contractors around 20. My lords, may kindly come to page number 166 of the paper book, my lords.
Yes.
I just, my lord. 165, order 163, your lordships, it starts operative portion, my lords. Petitioners are hereby disposed of. The respondents, state and other government agencies who have entered into works contracts with the petitioners are issued the following directions and guidelines. Calculate the works executed pre-GST prior to 1/7/17 under KVAT regime law. It is Karnataka VAT Act, and payments received by the petitioners. The payments received by the petitioners pre-GST for such works executed before so and so to be assessed under the VAT regime, either under my lord or VAT scheme as applicable. COT means, my lord, composition scheme, my lord. Calculate the balance works to be completed or completed after 1/7/17 in the original contract. Derive the rate of material so and so. Deduct the VAT amount from and the service tax if applicable. Add the applicable GST on these items. Input credit on the materials is to be arrived at and be set off against output GST so and so. My lord, further the tax difference. Then your lordships may kindly come, my lord, there, paragraph J. Supplementary agreement may be signed with the petitioners for the revised GST. That relates to a direction with regard to my reworking of the, my lord, the terms of the contract with respect of rates.
We will see it, Mr. There are so many directions.
Yes,
Not sure.
None of the directions are against me. The direction is this, my lord. I am agreed by this. GST authorities are directed not to take precipitative action against the petitioners for a period of 6 months from the date of receipt of the copy of this order.
Roman 6.
Yes, madam. Roman 6. Liberty is reserved for challenge any order so and so and so.
Why 6 months?
My lord, he directed them to, my lord, within 6 months, they must approach the authorities and rework the, my lord, the entire GST liability and, my lord, recalculate the whole thing.
See, if that process is undertaken, suppose if ultimately on rework, it is found nothing is payable, then?
My lord, for 6 months time, what, my lord, under the new GST regime, there is no such a scheme, my lord, where we could, my lord, undertake this kind of an exercise and not to enforce the demand. That's one aspect. And my lord, in 6 months time was given, even admitting, my lord, that the single judge was right. None of them have approached because these contracts, my lord, remained as it is.
See, what is the date of the order?
My lord, date of the order is
2021. 11/4/2023, Manoj.
11/4/2023.
6 months have gone by.
6 months have gone by, my lord.
So, you are within, it says 6 months. If 6 months have gone by, then
If
you
that
are within your
clarification
rights.
issued, my lord,
You are within your rights.
with that clarification, my lord, I seek a
Why do you
disposal.
require, it's a pure simple
Otherwise,
English,
my lord, it's,
simple direction, 6 months they say.
no, no, no.
So you must think over it, whether to pursue this.
No. I'm very clear in my mind that, my lord, I have advised also. 6 months are over.
You have advised. Very good. So we will dispose it off.
That's what, my lord, with that clarification, they want.
No, we will say the only submission is this. And you concede that 6 months are over.
6 months are over, my lord, as per the directions. Other directions are, several directions are there.
But challenging that 6th direction only.
That pertains to me only.
It's there.
That
Only
pertains to me.
agreed by 2 directions, my lords. All other directions is against the state government, my lords, wherein the employers were directed to recalculate and to pay the differential
You
tax.
just take instruction, we'll have it after 2 days. Take instruction, nothing survive. If this is the thing, 6 months are over, what remains? You must.
I only thing is that, my lord can dispose it off with that 6 months are over, then, my lord,
We
we are
will
at
not-
liberty to, my lord, initiate any appropriate action if
We
need
want-
be. That's all.
We want, it should come from you. That you must take instruction. See, this is your appeal. Next.
Great, my lord.
14/11.
My lord, there is some delay is there, my lord can condone it, my lord.
We'll condone the delay.
Kindly, my lord.
What is the number?
67 days.
67 days delay, just condone it for the reasons stated in the.
That's all.
Great, my lord.
14/11 circuit. Serial number 45.
Your Lordship, the assessee herein entered into a contract not with a foreign resident company. Your Lordship, the assessee wanted to set up one power plant. He gave contract to 4 companies. One of the companies NRC, non-resident company, and 4 works were allotted to those 4 companies. As far as the assessee is concerned, 2 works were given. One is in respect of technical services. The second one is in respect of work, physical work, which has to be done in India. As far as that work is concerned, here there is no dispute that he has to deduct the TDS and he has to remit. Your Lordship, the assessee also challenged that one, but that is held in favor of us. Your Lordship, what happened? This honorable court, when the assessee filed an appeal before this honorable court, this honorable court held as far as non-resident company, the technical services are concerned, which has been done by assessee in that foreign country, you are not liable to deduct TDS from that amount. So we filed SLP before the Honorable Supreme Court. In the meanwhile, there was amendment to the explanation to section 9(2). As per that explanation, subsection 9(2), even though assessee foreign company had given services abroad and services were utilized in India, there was a nexus, they are liable to deduct TDS. This explanation is with effect from 2010 with retrospective amendment from 76. Prior to this one, when the matter was pending before this honorable court, there was another one amendment to the explanation 2 to section 9, my lord, that is in respect of explanation 2 only, wherein that we had brought in amendment that there should be connection with the Indian company as well as the foreign company, even though they don't have any business establishment in India. So two explanations came into effect after disposal of the tribunal's order. So subsequently, there are also other decisions of Honorable Apex Court, how it has to be understood. Now the questions of law raised by the assessee before this honorable court in tax appeals are concerned, it is only with explanation 2. Now, another aspect of the matter is that the main foreign company we had also assessed the foreign company and orders were passed there. Tribunal has passed order in favor of the foreign company holding that there was no chargeable income tax. They were not liable to deduct TDS. Against that order, we filed appeal before the Bombay High Court and appeals are pending. That is the main appeal, my lord. That has to be heard first. My respective submission is that.
That will have a bearing here.
Yes, my lord, that is the main. They are the person who are liable to pay tax. These people are only deductors. Since they are not deducted tax under section 195, read with section 912 of the Act, my lord, coupled with DTA provisions, my lord, double taxation avoidance provisions, we have passed this order and they have challenged the same before this honorable court. So, Lordship, this is subject to the always, my lord, it is the person who is liable to be charged. That is income liable to be charged under section 9 is that foreign company. Those appeals are pending before the Bombay High Court. So, Lordship, my respect.
So the foreign company did not pay the tax.
No, they are not paid the tax. They are also contesting that they are not liable to pay tax.
They are saying so.
They are
saying so. ITAT Bombay has held in their favor that none of the payments made by us, Jindal to them, attracted any tax. Now 195, my lord, says that I have to deduct tax only if it is chargeable under income tax. That is why, my lord, the issue in the base tax is whether I was liable to deduct tax or not. Now, my lord, the division bench of this honorable court in 2009 gave a judgment saying that technical fees, which is rendered outside, is not taxable here. Relying on a Supreme Court 2007 decision, my lord, in Ishikawa's case, it is not chargeable. As far as, my lord, the overall responsibility is concerned, that is chargeable. They went, my lord, they then amended in 2010, as I said, Finance Act 2010, they amended and added this explanation, saying that even if it is not rendered in India, it is rendered abroad, even then, as per the explanation, it is taxable. So, my lord, when they find...
What is the finding there?
Now, that, my lord, they challenge the 2009 judgment in Supreme Court, and then in Supreme Court, they said that now 2010, there is an amendment. So, Supreme Court, my lord, in respect of two assessment years, 96-97 and 98-99, permitted them to file review based on the amendment.
What is the retrospective?
Retrospective is that even if it is not rendered, because High Court relying on lot 2007 SCC judgment, Ishikawa's case said that there has to be a nexus, and nexus for taxability merely because it has been utilized and the pay is here, that is Jindal is here, doesn't make the income taxable if all the work is done outside. It is not taxable. There is no nexus. That is what Ishikawa held. Based on that judgment, Lord, this division bench of this honorable court in 2009 gave the judgment saying that technical fees, which is about $15 million, there was no liability to deduct tax.
Them, if it is not taxable, what they are contending
TDS. I am saying even otherwise there is no liability for TDS because, Lord, in a recent judgment of the Supreme Court in 2022, they have said that where, by way of an explanation, a retrospective amendment is made. As far as the deductor is concerned, that is the liability under 195 is concerned, there can't be any liability because I am not liable to follow an impossibility in what is done in 2010 because my deduction was in 96. At that time, as per Ishikawa and as per the judgment of the division bench, there was no liability.
That's right.
So therefore, that 2022 is in respect of this retrospective explanation amendment only.
But effectively, you are challenging the retrospectiveness.
I am challenging the retrospectiveness on 2 or 3 grounds. One, based on this judgment that even if it is retrospective, as far as the deductor is concerned, it may have bring liability as far as real is concerned, who has to pay the tax. But as far as the deductor is concerned, Supreme Court says that if there is, in that case, my lord, from 2012, it was retrospectively amended to 1976, similar to our case.
Mr. Dutt, if ultimately the foreign company has gone to Bombay High Court,
yes,
let's assume two things. Either it is decided in their favor that there is no tax liability.
As of now, there is no tax at ITAT
because of
judgment
the
is not
ITA,
stayed.
because of the IT, because of the IT. But suppose, no, we are seeing, see, let's analyze the situation.
Yes, yes, my lord.
Suppose it is decided in their favor or the ITAT upheld, or order is upheld against the revenue.
Yeah, against the revenue.
Then there is no liability.
Yes.
Then that will possibly inure to your benefit.
Yes.
But
if it is held against me,
against you, then the tax liability is there, then this will follow.
Then not even then I will rely on this judgment that as far as the deductor is concerned, because there is an amendment in 2010, that doesn't bring any liability as far as the deductor is concerned. It may bring a liability for the payee, that is real. That because there is now,
as far as TDS is concerned, that cannot
be. That's the 2022 judgment of Supreme Court, my lord. Exactly on this. That's what I am relying on. And my learned friend said it is under review. That review is also dismissed.
Both ways you say, even the liability is upheld there against the foreign company.
Then nothing. Then if liability is upheld, then my lord, this 2022. If liability, as of now, if it is held that there is no liability, then in any case I succeed.
The liability is for the foreign entity.
Is the foreign. My liability is only 195 deduction if it is chargeable to tax. 195 is very clear. I have to deduct if I make a payment to a foreign company, provided it is chargeable to tax under the statute.
What does 22 say? Supreme Court 22.
No, 22 says that if there is by way of an explanation, if there is a change, like in this case, now they say by way of the 2010 explanation, even if it is not rendered in India, if it is utilized in India, therefore there is tax, it is taxable. Supreme Court says that if there is a retrospective amendment, taking it back to 30 years, as far as the deductor is concerned, he can't do an impossibility. He couldn't have foreseen that 2096 when I was to deduct, that in 2010 there will be an explanation which will make it retrospective from 1976. So therefore, as far as the deductor is concerned, there is no liability. That's what Supreme Court says. Exactly covering my case.
Your Lordship, as far as that one is concerned, man, Your Lordship, in 2015, here only, my Lord, there is one more judgment of the Honorable Supreme Court in respect of this same case, similar case, my Lord, wherein the Honorable Supreme Court has said that without relying upon the explanation, my Lord, even the section 9(7), my Lord, by relying upon the 9(7)(b), by applying source rule, cite as a source rule, but since the source is from here, my Lord, they are liable to deduct TDS. That was not applied by the tribunal, my Lord.
That case, my Lord, they were not concerned with the explanation or a retrospective amendment, which is the only ground which they raised, my Lord, for review.
You're right. Then there are two things.
Yes, ma'am.
What you are saying is there is a provision
Yes, ma'am.
existing. Unlike here, what he is trying to argue is this.
Yes, ma'am.
When they deducted, they were required to deduct the TDS. There was no provision. But at a later stage, from a retrospective, it has come.
Yes, ma'am.
So that liability is now sought to be imposed on him,
Yes,
that you are required to do it because of this amendment. You did not do it, hence proceedings.
Yes, ma'am.
Very well. But insofar as what you are saying is there is a provision for deduction of TDS.
Yes, ma'am.
There would be,
Yes,
or there is some provision also. In that fact situation, possibly the court was saying.
No,
But unlike are those things?
In our case, 2009 division bench of this honorable
this fact
judgment is there.
situation-
Yes, my Lord.
Their
In the
only
same
ground
set
was
of-
the amendment.
in the same set of facts, my Lord.
Same set.
Same set, that was also a non-resident
Let's see
company.
both the judgments.
Yes, my Lord.
Let's see, let's have your facts.
Yes.
Well, first may I read the section, my Lord, how it.
Which
Your Lordship,
section?
Section 9, my Lord.
May I, my Lord, first show, my Lord, the judgment of this.
So Sarmati, you sit down, let him
Please.
complete it here.
Lord, this is one, Lord, base tax is one. I am saying on the penalty, my Lord, I'll argue base tax, there is no difficulty. Penalty proceed, because penalty order is 2006. Base tax order, my Lord, ITAT is 2005 against me. High Court order is 2009, amendment is 2010. The penalty order proceeds on the basis that there is a liability to deduct. So that, my lord, is their appeal. There is a liability to deduct, but there is a reasonable cause for non-deduction, therefore no penalty. So penalty can be decided irrespective of, my lord, the base tax liability or not.
No, but in any case, that need to be settled, need to be decided only when your liability is first determined.
No, my lord, penalty is on a demurrer. Penalty, because in 2006, there was already a ITAT judgment that you were to deduct, it was chargeable to tax. But ITAT in the penalty proceeding said that, yes, you are liable to pay, you are liable to deduct, but penalty is leviable only if there is a contumacious conduct, if there is reasonable ground for not deducting, which they have discussed in detail, my lord, all the opinions of the law firm, opinion of the CA firm, and, my lord, the attempts made to get authority on advance ruling order, whether it is taxable or not, and my own application, all done before the survey of 17 December 1997. And there only one ground is in the penalty. That's why I said penalty appeal, my lord, will not take more than 10 minutes. It proceeds on the basis that there is already a liability, because 2006 is the penalty order of ITAT. But because there are reasonable grounds for non-deduction, therefore no penalty. Maybe base tax, but no penalty. And there one ground is that you took all these actions, this legal opinion and all these actions were taken after survey, which is factually incorrect.
But tell us, this is for which assessment year? Before 2010?
Before 96, 97. And your lordship will also note one more thing. 97, 98, my lord, which is the maximum amount of TDS is about 15 crores. Total is 19 crores, 80 lakhs. 15 crores is in 97, 98. There, my lord, they were not given liberty. It was kept in the Supreme Court and it is dismissed in default on 5th December 2017. So that has become final. Your lordship judgment of 2009 has become final, that as far as technical fees is concerned, there is no liability. That has become final. So, my lord.
Tell us one thing then.
Yes.
If 2006, what you are saying.
Yes.
The tax TDS, deducting TDS is there.
Yes. The ITAT held against me saying no, as per 917, see, there is a provision and you should have deducted. Then ITAT, yes, you should have deducted.
In which year?
In 96, 97.
Now, if that be so, will not that be?
Then, my lord, there is a judgment of the Supreme Court in 2007, Ishikawa, which says that for 917C, which is the provision at hand, it says that there has to be a nexus. So unless the services are also rendered in India, they will not attract tax. Only those part of services which are rendered here will attract tax. You may utilize the services here. So there, my lord, the contract was a composite contract. Some part of services were abroad, some part of services were in India. Just like in our case, our sister concerns did, my lord, the construction and erection work here in India. There is no dispute about tax. The only issue was what work is done outside India, whether that is taxable or not. Ishikawa's judgment came in 2007. Following Ishikawa's judgment, my lord, 2009, division bench of this honorable court held that technical services which were rendered abroad, which is about 15 million US dollars, there is no liability of TDS. Then, my lord, in 2010, to get over our judgment and my lord Ishikawa, they came with an explanation saying that even if the services are not rendered in India, from 1976, there is a tax liability.
Okay.
So that is, my lord, the situation. And, my lord, as far as the Bombay ITAT is concerned, it says that there is no liability at all. It has discussed everything.
See these judgments, both the.
Yes. Now, my lord, your lordship may first see Ishikawa's judgment, because that is followed in the 2009 judgment of your lordship. Yes. Give the copies. Yes, this is, my lord, 2007 3 SCC. And your lordship may straight away come to para 2 and then I will take to the para 2, my lord. at page 8, my lord, at the top.
Let's
there
read
is
the
page-
facts, Mr. Dar.
Yes. Yes, if you see para 2, just last 4-5 lines. Project was to be completed in 4 months. Contract indisputably involved offshore supply, offshore services, onshore supply, onshore services, construction and erection. Price was payable for offshore supply and offshore services in US dollars, whereas the onshore supply and onshore services partly in US dollars and partly in Indian rupees. Now, my lord, your lordship, a lot of my lord case law is discussed and come straight away to para 89 onwards.
Yes.
We would, in the aforementioned context, consider the question of division of taxable income of offshore services. Parties were eyed item that there existed a distinction between onshore supply and offshore supply. The intention of the party thus must be judged from different types of services, different as also different. Section 917C of the Act states as under. A person who is a non-resident Indian where the fees are payable in respect of services utilized in a business or profession carried out by such person in India or for the purpose of making or earning any income from any source in India. Reading the provision in plain sense, it can be seen that it requires 2 conditions to be met. The services which are the source of income that is sought to be taxed has to be rendered in India as well as utilized in India. So, but they say the provision, clear reading, it has to be rendered in India, utilized in India to be taxable in India. In the present case, both these conditions have not been satisfied simultaneously, therefore excluding this income from the ambit of taxation in India. Thus, for a non-resident to be taxed on income for services, such a service needs to be rendered within India and has to be part of business or profession carried on by such person in India. The petitioner in the present case have provided services to persons resident in India, and though the same have been used there, it has not been rendered in India. Section 917 of the Act, whereupon reliance has been placed by the learned additional Solicitor General, must be read by Section 5, takes within the purview the territorial nexus on the basis whereof tax is required to be levied, namely resident receipt or accrual of income. Global income of a resident, although subject to tax, global income of non-resident may not be. The answer to the question would depend on the nature of the contract and the provisions of DTA. Then, my lord, 93. Lordship can skip 93, come to 94. Section 917C clearly states where the fees are payable in respect of services utilized in a business or profession carried out for such person in India. It is evident that Section 917 ran its place, same envisages the fulfillment of 2 conditions. Services which are a source of income sought to be taxed must be utilized in India. Rendered in India, present case, both these conditions have not been satisfied. The provision of 917 are plain and capable of being given a meaning. There, therefore, may not be any reason not to give full effect thereto. However, even in relation to such income, the provisions of Article 7 of DTA would be applicable. Services rendered outside India would have nothing to do with permanent establishment in India. Thus, if any source services have been rendered by the heads of the appellant outside India, only because they were connected with permanent establishment, even in relation thereto, principle of apportionment shall apply. Then, my lord, kindly come to para, because 98 is offshore supply, but come to B, which is of next page, offshore services. Number 1, sufficient territorial nexus between the rendition of service and territorial limits of India is necessary to make the income taxable. Then 5 also, my lord, for section 917 to be applicable.
There is no dispute on this.
There is no dispute on this. This is the judgment. Based on this judgment, my lord, now your lordship may see 2009 judgment of this honorable court.
No.
Which led to the amendment of 2010.
There is no dispute, nor
there is no dispute that the services were, that's the finding, yes, that services were rendered outside. The High Court, my lord, in 2009 judgment says technical services rendered outside, but startup and overall responsibility, it has an excess here. Therefore, that will not be out of the purview of 195, but the out of, my lord, the majority amount, $15 million, which is technical services rendered outside, not taxable. After that, my lord, and that your lordship can see in there, if your lordship has, may I just finish reading it? Point 5.
Yes.
For section 917, it is necessary that the services not only be utilized, but also rendered in India, or have such a live link with India that the entire income from fees as in which is becomes taxable in India. And then, my lord, also 10, the location of source of income within India would not render sufficient nexus to tax the income from that source. So merely because Jindal is here and is paying from here doesn't mean that there is a nexus. It has to be, that's what my Lord Supreme Court says. And it is interpreting this very provision, 917.
Yes.
And then, my Lord, your Lordship may then see the judgment based on this, the judgment of this Honorable Court, my Lord. That is, my Lord, if your Lordship has their review petition memorandum.
The review was filed in which matter, Mr. Samir?
Your Lordship, income tax appeals, my Lord, assessee's appeal.
96, 97 assessment year and 98, 99. Because as I said, 97, 98 was kept in the Supreme Court. They filed, my Lord, appeals against the orders for all the three, my Lord, years. They filed SLPs. In two, my Lord, they were given liberty to seek a review based on the amendment of 2010. 96, 97, 98, 99. 97, 98 was kept in the Supreme Court itself. And that was dismissed in default, my Lord, on 5th December. We have got that order also. That order in 2017. So that order has become final.
Okay.
Now, my Lord.
2009.
Yes. Now see this memorandum of review petition, my Lord. And if your Lordship has, page 14, my Lord, is the judgment of 16 March 2009. It starts at page 14.
14 of what?
My Lord, this review memorandum which, my Lord, the department filed pursuant to, my Lord, liberty given by the Honorable Supreme Court in respect of 96, 97 and 98, 99.
I'm sure was that.
The review memorandum, because the judgment, my Lord, of 2009 of this Honorable Court, division bench is in there. We can hand over copies also, but it is there in the review petition, review memorandum. Review petition is there. This. Yes. At page, now, my Lord, your Lordship may see it starts. Para 1 says all appeals pertain to same subject matter involving similar questions of law and fact, hence all are heard together. Material facts are as are under, my Lord, then facts are noted. And if your Lordship turns the next page, there are three categories. Last 4-5 lines, my Lord, of page 4 of this, my Lord, judgment. Remuneration to be payable under three categories. Technical services. Technical services were to be rendered entirely outside India, includes the following services, my Lord. Then the services are noted. And then, my Lord, startup services. Home office startup support. Then that is noted, my Lord. And then, my Lord, at page 7 top, overall responsibility. And that is noted. Then, my Lord, para 2 is Jindal while making payments to Riyal under contract, initially deducted part of tax liability by way of, for the assessment, no TDS deductions were affected. Then, my Lord, it in the contention that the initial remuneration agreement under the contract for technical services was, it was this. This was subsequently modified, my Lord. The contract value for technical services modified to 14.484 million, startup 6.235, and overall responsibility 10 odd. Assessing authority issued notice, my Lord, then the facts are noted. Then, my Lord, our argument is noted at page 9. Jindal before has canvassed the following grounds. Then, my Lord, your Lordship may see page 6, page 11, para 6, my Lord, both parties were heard. And the following points would arise for consideration: whether the payments made to Riyal attract tax liability under 917C, read with explanation to section 92 of IT Act, and whether Jindal was obliged to effect TDS in payments made to Riyal under section 195 of the IT Act. This is, my lord, the points for consideration. And then whether services rendered are ancillary and inextricably linked under the DTA. Then, my lord, your lordship may come to arguments of the additional Solicitor General are noted, my lord, Mr. Parasaran. And then straight away come to our arguments are noted. And then page 23. The contract has three aspects. The first deals with technical services. The rendering of basically involves overall conceptualization of the plant, technical logistics, design, nature of theoretical formulation. In this regard, subsidiaries have no role to play. Their job is essentially the executory part of the contract. The rendering of theoretical aspects of technical services could be done wholly offshore and outside India. Therefore, the first aspect of the contract could be contract distinguished from the startup services and overall responsibility. In respect of later two, it can be held that RIOL is equally involved in executory part of contract. Therefore, the twin criteria of rendering of services India and utilization of services India become evidently noticeable in respect of startup services and overall responsibility. However, in respect of technical services, the rendering of services being purely offshore and outside India, the remuneration, whatever paid towards, does not attract tax liability. However, the split up remuneration paid towards startup service.
This was taken in appeal to the Supreme Court.
This was taken in appeal to the Supreme Court after the amendment. Now, please see the amendment in 2010. After this judgment came, my lord, they, by the Finance Act of 2010, amended and added an explanation retrospectively with effect from 76, saying that irrespective whether it is utilized in India or not, it is taxable.
What does Supreme Court say?
Now, Supreme Court said on the basis of these two, this amendment, please give you liberty to seek a review of this judgment in respect of 96, 97 and 98, 99.
Review where? Here.
Here. File a review.
What happened in the review?
In the review, my lord, in 2005 was allowed to the extent that the court said that we will now hear the matter on merits.
2000, no, this must be when
2015. It was, the date is not 24th July 2015.
2015 minute.
Yes.
Yes, where is that order?
Yes. Give that order. Lordship may also see the amendment, retrospective amendment also, because just show it. Because that 2022 judgment, my lord, is only on this aspect. This is 2015.
Para 2, my lord.
Para 2 and para 3. Finance Act 2000 operates with effect from 1st June 1976.
Now, this review petition is in ITA 3025.
Yes, my lord. The present the cases, my lord, which
3023
the same cases, my lord.
3023, 3025 and 3026.
Is part of this batch?
Your lordship,
Yes, part of this.
your lordship, earlier judgment has been set aside, my lord. Now the your
Earlier
lordship is
judgment
hearing.
on the basis of this, of the amendment. Basically on the basis.
Clear judgment was insofar as the startup is concerned, liability
Liable to tax.
there, instead of a technical service is concerned, no liability.
No liability.
But now the amendment has come.
Now the amendment has come.
So we have to see the
Now,
applicability of-
therefore, my lord, 2022 judgment. It says that if there is a retrospective amendment, as far as the deductor is concerned, liability for TDS, you cannot ask him to perform an impossibility. Therefore, there is no liability as far as the TDS deductor is concerned.
What was held in that Vodafone? It was also a retrospective.
It was, but there was a challenge to the retrospective.
But not in this manner.
Not in this manner. There was no issue. There was an issue of tax liability. RIOL will face that issue. What will be the effect of the amendment? But as far as my lord Jindal is concerned, in view of this 2022 judgment, we cannot be, my lord, made liable. That's the submission, and we will not, please place that judgment.
Yes,
That judgment will not, we have filed on record with our written submissions.
show us that 22.
Your Lordship,
Yes.
in review petition judgment below also GVK Industries has been relied upon
Yes,
by revenue.
GVK is also not dealing with the
We
tax
did see that,
deductor
but
for
see-
retrospective amendment.
We will see that. In fact, the review says so, GVK.
Yes, no.
Review says so, GVK, because at that time, not this 2022 was not there.
Engineering analysis, same.
Now, my lord, please see this. This is part of our, my lord, written submissions, which were filed on 17 January 2024. This we have filed this judgment, my lord, of the Supreme Court.
Now, where was the issue urged?
Yes,
Where was the
please
issue?
come to para 79 onwards. There, my lord, 9-1, it was a retrospective amendment in 2012 from, by way of an explanation, just like our case, explanation, from retrospectively from June 76.
Not in the context of TDS.
No.
No, but the discussion is on the basis of TDS.
Prospective.
Yes, on the basis of TDS. Whether there is a liability to deduct a TDS in view of the amendment of 2012 in that case, in this case, where royalty, my lord, definition was expanded in 2012. So therefore, your lordship may straight away come to
Royalty.
no royalty, but whether there was a liability to deduct because there was a retrospective amendment in 2012. Here also, my lord, it was the assessment years were before the date of amendment.
Let's see 79.
Para 79. The lordship has this, my lord?
Yeah, we have this judgment. We
Yes.
have SCC.
SCC, my lord, I have a different copy. You have
No, sorry. This is engineering analysis.
Yes. Engineering analysis. Maybe वो SCC नहीं है ना? यही तो problem है. This is, my lord, my copy is downloaded from the Supreme Court website. It is part, we filed it as our as an additional submission.
Mr. That you have SCC.
You have SCC?
You have Mr.
Yes.
Just
Then
read-
not straight away, I will come to the relevant paragraph. Paras are not the same, so I'll just give me 1 minute. Yes. Come to para 81, I think, my lord, in this. There it was 79.
We start with this position of law or comma.
No,
after
it
the word.
is,
The comma after the
1
word
minute.
copyright.
yes, para 90.
Oh. 90.
90.
How does it start?
91. Learned additional Solicitor General then argued that being covered by explanation 4 of section 917. Now, my lord, I will just show this explanation 4 came into existence in 2012 with a retrospective effect from 1976. Learned then argued that being covered by explanation 4 of section 917 of 916 of the Income Tax Act, the persons liable to deduct TDS under section 195 ought to have deducted tax at source on the footing that explanation 4 existed on the statute book with effect from 76. Exactly, my lord, what our case is. We are therefore to examine as to whether persons liable to deduct TDS under section 195 of the Income Tax Act can be held liable to deduct such sums at a time when explanation 4 was actually not
There.
there,
On the
not
statute.
on the statute book, all deductions liable to be made and the assessment years in question being prior to the year 2012. In this case, not 2012 was the explanation 4, which came retrospective. In our case, it's 2010. The question is answered by 2 Latin maxims. Lex non cogit impossibilia, the law does not demand the impossible, and impontotia executat legum, where there is a disability that makes it impossible to obey the law, the alleged disobedience of the law is excused. Recently, in the judgment in so-and-so delivered by this court, the court applied the said maxims in the context of the requirement of a certificate to produce evidence by so-and-so. Then, my lord, various judgments are noted on this principle of impossibility of performance. And then your lordship may turn the pages because we did not read the said judgments and come straight away to 93. Various judgments are noted, my lord.
Yes.
As a matter of fact, 93, even under Income Tax Act, the High Court of Bombay has taken a view applying the aforesaid maxims in the context of provisions of relevant DTA to hold that persons are not obligated to do the impossible to apply a provision of statute when it was not actually and factually on the statute book. In CIT versus NGC networks, a question arose as to the applicability of explanation 6 to in section 916 in the context of section 194J of the Income Tax Act, which explanation was inserted with the retrospective effect. The High Court of Bombay, applying the aforesaid maxim, held, we find that view taken by the impugned order dated so as the tribunal that a party cannot be called upon to perform an impossible act to comply with a provision not in force at the relevant time but introduced later by retrospective amendment. This is in accord with the view taken by this court in CIT versus so-and-so, wherein this court has applied the legal maxim, law does not compel a man to do what he cannot possibly.
This SLP arises from Karnataka, this court's judgment.
And
Yes,
then,
sir, Samsung case.
then
Yes,
please
sir.
see 96.
In
Please
batch
see
of cases.
96.
Batch of,
95, another judgment is.
1 minute, Mr. Dutt, 1 minute.
batch of synopsis and Samsung cases are part of this in batch, my lord.
No, whole thing, I have seen the,
Yes, my lord.
everything arises from here.
Two judgments from this honorable court.
Why two, Mr. Sam? You see?
Samsung and also synopsis, both two cases.
So
were-
there is a huge list here.
Yes,
a
a
huge
huge list, my lord. Your lordship in.
You see the very.
Yes, my lord.
And see 96, my lord. It is thus clear that person mentioned in section 195 of Income Tax Act cannot be expected to do the impossible, namely to apply the expanded definition of royalty inserted in explanation 4 to section 916 for the assessment errors in question at a time when such explanation was not
What
actually.
does ultimately sum total of this?
So this is, my lord, the sum total is that as far as the deductor is concerned, 195 is only, my lord, TDS deductor's liability. As far as the deductor is concerned, there is no, my lord, liability if you are relying on an amendment which has come subsequently, my lord, in 2010, as in this case, retrospectively amending it from 1976, saying that irrespective of whether services are not rendered in India, still they will be taxable as per 917. Now, this being the position, whether, my lord, Real succeed or not, my lord, as far as this case is concerned, in view of this judgment, my lord, and review has been dismissed because my learned friend on
Why
20th.
there are 3 appeals by you?
I beg your pardon, my lord?
Why there are 3 appeals by you?
My 3 appeals, because one is for 96, 97 assessment year, then, my lord, interest for that year, and then, my lord, 98, 99, there was no assessment. I filed a suo motu appeal under section 243 of the Income Tax Act. I can file a suo motu appeal. So that is for that. 97, 98, as I said, kept in Supreme Court, dismissed in default, my lord, in their appeal, dismissed in default. In 90 and became final. So therefore, that 2009 judgment became final as far as that assessment year is concerned.
But there is a review sent now.
No, review is, my lord, for these two assessment years. For that assessment year, my lord, there was no review. It was kept in the Supreme Court. Supreme Court dismissed
What
no,
would
for
happen
non-prosec.
in that 97, 98, 96, 97, which was dismissed in default?
97, 98 was dismissed in default.
Your lordship,
Attain finality.
Yeah,
No,
it has
sir.
attained finality. Just give me-
your lordship, I will ascertain whether any application for restoration.
No,
has
no,
been-
we are now in 24. I am saying it is dismissed.
Whether it's filed or not, I will just.
No, but what he is saying is it has attained finality qua that assessment year.
Yes, qua that assessment year, there is penalty as far as 2009
As a
judgment.
fact, no, as a principle of law, in the sense that it has now attained finality and whatever transpired in that assessment year, did it inure to the benefit of the appellant?
Since
will
it's
involve-
not on merits, my lord, it will not have a bearing, my lord.
No, but we want to, not on the interpretation of this provision, not on interpretation, we are sure that.
Yes, my lord.
But now insofar as that is concerned,
Yes, my lord.
like these 2 appeals which are pending.
Yes, my lord.
But 97, 98, whatever happened in favor of the appellant has attained finality.
Yes,
Yes.
That's what he's trying.
Since it's not been restored.
it has, 7 years have passed, my lord. It was dismissed for non-prosecution. That order, your lordship can see. Yes, we have given an order, my lord. In fact, it was passed by Justice Chandrachud, my lord, at that
Which
time.
was in which year? This was 17.
This was 97, 98. And
Order, date of order.
order is 5th December 2017. And we are in 2024, my lord, and
But no,
Sir, give me
So
copy.
that
of it.
order, you would not argue that on a default, it has, okay, now everything must go.
No, I am only saying for that year it has become final. For these 2 years, obviously, my lord, we are here. I am not saying that. I am saying only for that, because my lord, TDS for that year is the maximum amount. 14.5 crores is for 97, 98.
Rest years,
Rest years is my lord 2.5 crores and 2 crores something.
these appeals.
Yes, these appeals. So that my lord was the substantial amount. It was kept in the Supreme Court itself. And my lord, it was dismissed for non-prosecution.
Okay.
Now, my lord.
We will continue, Mr. Dutt.
Yes, just one thing, my lord, as far as this is on base tax. No, as far as the penalties appeal is concerned, your lordship may just see it is just a one-page appeal, one ground. And it is on the basis, my lord, and I am also arguing it on the basis that yes, there is a liability. Because ITAT says 2006, this High Court judgment was not there, Ishikawa was not there, there was no interpretation of this 917. ITAT says, yes, 271C, you have a right to impose penalty, but it is subject to 273B, which says that if there is a reasonable ground for non-deduction, then there is no penalty. And my lord, just see the ITAT order. It is a very well written order, my lord, citing all the judgments at that point of time. Yes. Written arguments have been filed even in, my lord, the penalty.
You have filed your submissions?
Yes, in both.
Your lordship, in brief, I have filed. my lord.
You file it, whatever he is arguing, Mr. Dutt.
They have filed, my lord. Both parties have filed.
Chalo, when do you want?
I have filed both penalty as well as the tax, so both submissions of the revenue in brief has been
The
filed.
appeals also,
Yes, my lord.
on that penalty also.
Both have filed in brief. my lord.
No, you
They have filed both.
You want to file it?
Additional, I will file one more.
File additional, give them a copy.
Please.
Just say that we have heard Mr. Suhail, the senior counsel for the appellants. In what, there are 3 matters, no, for them.
Actually, there are 5, my lord. There are 2 penalty appeals also for the year.
In 45, 45.1 and 45.2. To come up for further submissions on, when do you want, Mr. Dutt?
Can it be, my lord, second if it is convenient to the court? It's a
No,
Monday.
we have to have Monday.
Second is the Monday, my lord.
And that will, what are the?
Second
what
is the
our
Monday.
position?
If it is possible.
Can have it later there.
Second is a Monday.
Second is Monday. We have it on the day. 9th is a holiday. 9th December. We have not, such a 9th is 22. We'll have it on 2nd.
Very grateful. I'm good.
Yes.
Page number 13, my lords, had heard and reserved it. There's one document, one judgment referred to, which is of a learned single judge. We just got to know it's been affirmed by this honorable. This case, I've sent it.
Who are the counsel?
Dilip, madam.
Mr. Dilip.
I have already informed him.
Informed him, give him a copy
I've
also.
also given him a copy.
Just give it to Mr. Sanmati or someone so that they can give it to.
I'll give it to
Just say that Mr. Dilip, he has relied. Just give it, ma'am, take it. Take this along with that compilation, na? Just tag it. Sure.
Much of you.
Good. Just keep it along with this. In this.